All right, before we get on to the next agenda item, we have two statements to read. So, Mr. Albert, do you want to go first?
Yeah, I'll go first. Okay, as many of you know, I've had two recent verbal altercations with members of the public outside of my role as a select board. Despite the tremendous harassment, stress, and anxiety that my family, extended family, and I have been subjected to over the past 16 months, my interactions were inappropriate, and as an elected official, I am held to a higher standard, and I understand that the residents of Canton expect public officials to always conduct themselves professionally and focus on the business of the town. I apologize for my recent reaction and will refrain from any further public incidents that are unbecoming as a member of this Canton Select Board. Thank you.
The hell are they clapping about?
An additional statement, Chief Rafferty has placed Kevin Albert on paid administrative leave while an outside, and please be quiet.
I just have to stop right there. I've never seen somebody issue an apology and get applause. That is so weird, man. Like these McAlberts, they're like, they don't pick up social cues. Not the brightest bulbs. Who the hell claps during an apology? If you can call that an apology.
While an outside independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago, Kevin Albert was placed on leave on June 13th and will remain on leave until the results of the investigation are provided by the outside independent investigator. All right.
All right, first on the...
I just can't believe this. It's unbelievable. We got the guest that everyone wants to hear from today, Attorney Mark Bederow.
That was kind of funny.
Wasn't it? I mean, what did you think about that last night? It was just...
well, that was that... if you call that an apology, that was... He read it, never looked up, read it in monotone, couldn't even read it properly without stumbling over it. Called himself a select board as opposed to, I don't know, a member of the select board. And then, as you said,
board member. Yeah, I know, right? I mean, he just could have said it 3 different ways that didn't sound stupid.
And he gave the classic non-apology apology by starting out by saying, I'm a victim, but I'm sorry for what I did. And then they all clap for him. And, you know, I guess the people of Canton, you get what you vote for. So that's what you get. So do something about it, or don't complain, or just laugh like those of us who don't live in Canton and watch the way that guy reacts. That was not a real apology. That was embarrassing.
Have you ever seen anyone get applause for issuing an apology?
No, and certainly not for somebody who does this, says, I'm very sorry for, you know, and then stumbles over it, but I'm sorry. I mean, who believes that?
He didn't even really say what he did either. I mean, kind of, but not.
Well, he said that he's a victim of harassment.
Yeah, that's what I heard. I didn't hear him say that I made a violent threat to somebody in front of my pizza shop with 5 goons behind me. I didn't see him. He didn't say that, did he?
I guess he'll have to say it all on the stand if he's a witness in the upcoming trial that they're having about witness harassment and whatnot. It's
it definitely got to help Aiden Turtleboy that he had to issue that apology, right? I mean, I would think so. What do you think on that? Does it help Aiden's case?
Well, it can't hurt. It can only help in the sense that if you're claiming to be intimidated and harassed and in fear, I mean, wasn't that even what they had told the DA during Karen's trial about why Aiden had to be barred from the courtroom because the civilian witnesses were intimidated? I mean, the Alberts and the McCabe's were intimidated by being within 20 feet of him, and yet everything they do and say appears to the contrary of that. So, yeah, I don't think they have a lot of credibility anyway. And we'll see. But it's all just part of the ongoing circus.
It really is a circus. And then Kevin Albert. I mean, this was just this is
Well,
crazy because I like our Canton coverage. We've been airing these select board meetings for over a year now, and the numbers were like a year ago were huge, and then it kind of had a lull. This last one last night, over 50,000 just on ours, and other people broadcast it too, and it's been shared everywhere and like other clips. And the one before that was 100,000 people watching a select board meeting just for us, just for my channel. Never mind all the other places it's getting. It's just I've never seen anything like it. Like they pouring gasoline on it, and then Kevin Albert. It's like Chris issues the apology, and then Kevin Albert gets suspended, and we don't really know why, do we?
Well, you know why? Because he's
Yeah.
drunk out of his mind, hanging out with a dirty, corrupt state trooper, losing guns and driving around wasted, and they're only in trouble because it came out and was reported in connection with Karen's trial. So, what is this chief who apparently, I don't follow the Canton stuff that religiously or really at all, other than when you guys talk about it. She's fighting for her job, and so she wants to look efficient and fair. So, how do you not suspend a detective who is running around like a drunken buffoon, losing his gun, and the person he's hobnobbing with, getting wasted with, is the corrupt, disgraced, for now, well, not really, not state trooper, but still state employee for now, Michael Proctor. These people have all had a hell of a week since the acquittal. I might have lost count, but Proctor is essentially 9/10 of the way to being terminated. He's disgraced his entire agency. Kevin Albert has been humiliated and suspended. Chris Albert just looks like a fool with that half apology. And by the way, 33% of the jurors are saying we acquitted on two-thirds of the count. So it's been a good week for them since since what we call for now the non-verdict happened.
So let's talk about that, because now we know we have 4 jurors. Now there's a rumor there's a 5th juror for Mike Shudak, apparently on Twitter and X. Looks like there's maybe up to 5 jurors so far, like that are kind of out there. At least 4 we definitely know of.
Well,
What happened?
To be clear, to speak really carefully, there's definitely 2 who Alan Jackson has sworn under oath that told him that. There are another 2 that David Yannetti has sworn under oath that he was told by an intermediaries that share the same view. But I think the most important thing you saw in the affirmation from Jackson today is what we alluded to previously, which is how many is it going to be? And apparently it's going to be 12 out of 12, at least according to this one juror. Now, that's never a fact until it's a fact. But, if this one juror said we were all aghast and appalled at what was happening, you got a lot more detail today. And the more this gets reported, you probably will get more detail. But it would appear that all of the jurors, if you believe this, and I mean, there's no reason not to believe, these lawyers are not making this up. This is what they're being told, is that the jurors, to a man and woman, acquitted on 2/3 of the charges and are upset to varying degrees, perhaps, that it ended the way it ended. And, so there's a lot to digest and break down from that. But it's real and it's serious.
Now, I've seen some other legal analysts on Twitter. I even push back at them a little, maybe too much, but they basically were putting blame on the defense, not the judge, for the situation because they didn't contest it. I feel like the judge didn't give them an opportunity, and we don't know what they said in sidebar. What do you think about that? Like, did they make a mistake, and is that really going to screw them?
You can say, as a Monday morning quarterback, should they have jumped out of their chairs and say, Judge, we want to know, and then who knows what she would have done. But, on the same token, the judge should have clarified that as well. And, also the judge did not give them an opportunity to do or say anything. She just basically said, I'm granting a mistrial, and dismissed them. And at that point, the cat's out of the bag. There's very little to do. But if this comes back before her, and you have 12 out of 12 jurors in some form are saying that this is wrong, I think it would be a huge mistake for the judge to basically say, I'm not even going to hear this because, you, sir, should have said something, and I chose not to say something, and too bad for you. It's also going to be very interesting to see what the DA's response is, because on the one hand, even if they want to make procedural arguments to say you shouldn't hear this because they waive their right to be heard, which is more like an equity argument. It's, a fairness thing. The judge could still probably do it and just say, I'm going to allow it. Ironically, is her expression, I'll allow it. This will be the one time she'll say, I won't allow it. But if the DA takes the position that you shouldn't even hear this, this should be dismissed out of hand, on the papers without a hearing, then they are running into another political head first into a brick wall, because what any real prosecutor would at least say is, I'm worried about this. It's concerning that, if the jury acquitted, from what they're telling us, at least up to now, that they believe they acquitted her from murder charges, and we are telling the court that we want to retry her for murder, one might expect a reasonable and fair prosecutor to say, well, let's make sure they didn't acquit her before we start, wiping our rear ends with the Constitution and just say, who cares? Let's have another crack at it. That's obviously not something they should be doing. But given who these people are, I fully expect them to argue what I would call almost weasel-like arguments, just arguing on procedure and saying none of this is real, none of this should be heard. This is all after the fact. They didn't check off the jury form, which it sounds like they didn't, based on the affidavit today, because they didn't know what they were supposed to do. And if everyone in this process is not concerned that the jury might have been confused, such to the point that 12 out of 12 are prepared to come in and make sworn statements saying, I swear to God, this is what we did, to not even listen to that before issuing a ruling is just going to feed the image, how awful people already perceive this, and how there's no justice in this county, in this court, in front of that DA. And I think it would just be a huge political mistake on top of a poor legal decision, and will put much more pressure on the DA. I think it'd be very short-sighted. They need to have clean hands. They ought to let this play out. And if they want to argue against it, I mean, the evidence may support them. I don't know. Maybe one of the jurors will say, well, I don't know. I really hadn't made up my mind. If that's the case, that's no verdict. Maybe the explanation for not checking off the jury form is substandard. I don't know. But what I read today in the affidavit is 1,000 times more disturbing even than you read in the prior affidavits, because you're starting to get reasoning and thought process and what's going on and concern, and explaining that we were immediately upset. Now, again, the part that's left out here is what the hell happened in that conversation with the judge. That's not answered in this.
Yeah, there's a question that came in related to all this too that I want to read. They said, Mark, the judge said not to fill out the jury forms until they came to unanimous verdict on each count. So isn't this her fault?
Well, that's why there ought to be evidence. And if the jurors are going to say we didn't check off the box, or we didn't even ask what to do, is because we were told we couldn't do this and we didn't understand. And if you can march in 12 jurors who are going to say that, how do you not at least consider that and think about what you're doing, as opposed to just dismissing this out of hand? Those instructions are confusing, and the juror in Jackson's affirmation today seemed to establish that they didn't really know. And they said something else, or Jackson reported what one of the jurors said that I thought was really interesting, which was, again, they don't know how this process works. Okay, so all the talking head lawyers know that in Massachusetts, if they come back after getting what they're calling the Tui Rodriguez charge and what the rest of us call an Allen charge, that she's going to have to grant a mistrial. The jury doesn't know that. And if you look in the affirmation today, they were like they didn't know that game over, and they had no chance to do anything, to say anything, to ask any questions and raise this issue. They were told right away, I'm declaring a mistrial. And at that point, they're all slack-jawed, looking around, perhaps. What happened? They don't know. They're not lawyers. Some of them are lawyers, but maybe not, experts in what's going on here. And you may very well not have had a meeting of the minds between what the jury wanted to do, what they in fact did do, and what the judge in fact determined. And to me, the people to watch here is the DA. Are they going to literally try to beat this down on procedural grounds and say that this is a frivolous issue and one that shouldn't be considered? And if they do that, I mean, they may have a legal right to make that argument, but that tells you everything you need to know about the Norfolk DA's office if this is the way this plays out, because they have at least reason to be concerned today that the jury may have been schnookered and didn't know what they were doing. And that's not right. Whatever they think Karen Reed did or didn't do, fair is fair, right is right, wrong is wrong. If they acquitted her, it would be quintessentially un-American to retry her. And we'll see what their attitude about that is. But based on their past history, one can only assume it's going to be, if it ain't in writing and the judge didn't say it, we're ready to tee it up again because they're zombies. Maybe this will be a chance for them to prove they're not. I don't have high hopes.
No, there's Sean McDonough. We've mentioned his name a bunch of times. I actually tried to get him on tonight. He's busy. Ex-DEA. He's been posting a lot of stuff about the jury and the McAlberts. One of the things, and again, I haven't confirmed this. I'm just, one of the things he said that the McAlberts had somebody on the inside telling them, leaking them information that they might get the manslaughter, that they, I mean, that kind of stuff, like we can't confirm it, but like there's another question that came in related to it too, that I just want to put up here. Here it is. Why is no one discussing that Proctor's text buddy was one of those that was in the juror's office, Detective John Fanning with the Mass State Police?
I mean, this is, again, part of the whole problem of this case being tried in and for the county of Chinatown. I mean, this is, it's incestuous. Everything that happens in this county or that town where this happened, we talked about, appears to be just incestuous. And the fact that the state police are the ones that are apparently responsible for monitoring the deliberations, monitoring is not the right word, but for securing them, if you will. But the fact that one of those people is somebody who is getting text messages about this case from a disgraced, dirty, corrupt, soon to be fired trooper, and did nothing about it, and is he leaking stuff to the Alberts or McCabe's? I don't know. I like Sean. I know Sean. He has a lot of good information. I'm not doubting what he's saying is true, but I don't know that that's accurate. So I don't want to say anything about it. But if it is, well, that's really disturbing. I mean, that is absolutely corrupt if that's happening. If somebody is literally leaking sacrosanct jury deliberation information to witnesses in the cases who just happen to be of the same people who showed up, Godfather 2 style, staring at the juror at the request of, the brother of the deceased. I mean, this is all just, if this is all true, it's just repulsive, and there ought to be more punishment. And if he did, then Fanning, he should be fired if that happened.
If it happened, yeah.
If it happened,
you should take a look at it. I think they need to remove all conflicts that they have. Like, they
course.
need to really go.
But let's
deep
be
on it.
clear. If he literally is leaking confidential jury deliberations to people that are that are witnesses in the case and are alleged by one party to be the actual bad actors, and he's also conflicted by his relationship with Proctor and all of that. If he did that, then, he's going to get the same union due process that Proctor got, but, tee it up and start it if you can prove that, because that's outrageous if it's true.
There's more comments and questions about the judge's verbal and written instructions. Here's one. says the judge's exact instruction was don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
It's confusing now in context. I mean, I suppose in the normal case, if the judge is basically saying, I don't want to know what you're doing until you tell me you have a verdict, I get it. In other words, I don't want you to send a note and say, we're 9-3 not guilty, but we don't understand the law on this, right? This instruction is essentially telling me, I don't want to know what you're dealing with numerically. The concern is in the context of 3 separate charges. There's a possibility of, not agreeing on some and agreeing on others, and not asking the question, at least, if not even asking the question, at least making sure you've got to go down the line on each count and make sure. And by not doing that and then telling them, don't talk to me about any of this and don't write anything down unless you have, the guilty or not guilty at the end. And they say, well, then we didn't know what we were supposed to do if we had a hung jury. And then she just immediately says, thank you for your time, mistrial. And they didn't get the opportunity to be heard. You may not have a meeting of the minds. I mean, the worst outcome in a trial from a sense of fundamental fairness can be that a jury reaches a determination, or not, in this case, non-determination, apparently, without fully understanding what the goal of the exercise was and how they were supposed to communicate their finding. I mean, that's just not just. And the reality is, if the evidence credibly supports that they had a not guilty finding, the benefit ought to go to the defendant. Okay, that's how the American system works. You don't err on the side of retrial for an acquitted charge because, shame on the jury for being stupid. And when you listen to that, or when you read that affirmation today, it seemed entirely reasonable. They didn't seem to be stupid, and they were immediately apparently shell-shocked by this. Now, again, what does that mean? Did anybody say anything to the judge? But the problem is this for the judge. You could have jurors, if you get a hearing on this, okay, and let's assume you get 12 jurors who are willing to say, that's what we did. I mean, unless this one juror today is lying to Jackson, it's not likely. Not likely at all. You may have a situation where, no, the jury didn't say anything to the judge in that 5-minute meeting, but you may have testimony from jurors who say, we were all looking around at each other, shaking our head, gesticulating. What do we do? Do we tell her? Do we not? Are we scared? In other words, there could be, even though no actual discussion with her, the jurors could have been acting in a way where they were clearly uncomfortable, indicating that they were immediately bothered. And this is going to make the judge a witness.
There's another comment about Fanning. It says, to clarify, Fanning role with the jury was to do the Corey checks. Those are the criminal background checks, and investigate any security or safety needs. Given his links to other cases, he was with Tully at Turtle Boy's house and in the Birchmore case. And and he was on the text chain too. With
the text chain is, look, the Turtle Boy thing in Birchmore, again, it is not, it's not New York County or Los Angeles County. There's going to be overlap. Some of that is unavoidable. He works in the court, so cases that come into the state police in that county, he may have some involvement in. The problem here is he's got a direct connection to the bad actor in this particular case. And more than that, the allegation that's being made, and it was apparently revealed to Sean, is that he was doing something improper and trying to benefit prosecution witnesses with information about what was going on. And
I want to just make sure I clarify that too, because Sean didn't put Fanning two and two together. I just kind of put them together. Okay. So Sean was basically not naming anybody. I just want to be clear on that.
Well, I don't.
But other people are calling out Fanning. So I'm
Well,
just saying they're kind of similar. It's like this whole
I
thing that
don't-
we don't know what's going on here.
I don't know who he is,
Yep.
and I'm not suggesting he did anything. I don't know what his connection to any of these people are, but I would say generically, if any state trooper or employee of the Massachusetts State Police was
Or
tasked,
anybody at the court.
or
it could be
anybody,
a court officer too. Could
But
be. I mean, who knows, right? I mean,
But
that's the thing.
even worse, if your duty is to like protect the integrity of the jury during this process, and you literally have, or proverbially have your ear to the door, and then you run over to tell, these other people what's going on, then that's a problem. And that ironically is a major security breach by the guy who was tasked with the responsibility of preventing exactly that. So that would be bad.
It's a few other. You know, I got another question for you. I got Mazza too. I'm going to bring him up in a second. But Albert, there's also some allegations that the jurors felt bullied or intimidated, let's say, by the Alberts being in the courthouse that day. The three of them.
So that's not going to do anything unless there are specific allegations that I saw Brian Albert or whoever, make a gesture, do something. He was allowed to be there. It may strike most people as distasteful. It certainly strikes me that way. All of them, in particular, Colin Albert, just because that clearly to me is contrived and for nothing other than the purpose of making a mockery out of something that was supposed to be, presumably serious. They were invited by Paul O'Keefe, which is, I mean, I don't even know what to say about that. So there's nothing to say about it. It is what it is. But if they just sat there and as a result, some of the jurors felt intimidated, that doesn't rise to the level of, I mean, the guy has a head that is, bigger than a football. Okay. He has no neck, right? He goes like from head out to here, straight to shoulders. He's huge. He's a physically intimidating looking guy, but that doesn't mean he is a bad guy. Literally. I mean, he looks like a meathead. Okay. I get it. And it may be intimidating to the jurors, but it doesn't mean that he was doing anything with the intent to be intimidating because he looks like that. Now, we can all roll our eyes and say, come on, why is he there? I get it. But because jurors may have subjectively felt that he was, there to intimidate them, that's not going to go anywhere. That's not going to lead to undoing a verdict. That's not even an issue.
What about the if they have a retrial? Would that be possible to say, hey, look, last time jurors complained they were intimidated. Let's not let them sit in this,
No, because it's a free country. Courtrooms are open. I mean, in this particular case, for the most part, the parties, whether it was Karen Reed's family or the O'Keefe family, kind of dictated for the most part who could go in because there's so limited seating. But the only time that they would not be allowed in is if they're on the witness list. Now, could the defense put them on the witness list just for that purpose? Yeah, they could, but they would probably call them. So there's nothing wrong with that. But you're not even going to see if the defense gets a hearing about the non-verdict being at least a partial verdict, you're not even going to hear them argue that Brian Albert or Jennifer McCabe or Colin Albert is part of this. That was included in I guess that was in David's, I think, affirmation. You know what? That's similar to, shame on you, Trooper Proctor. Okay. That's a dig. That's what that is. It's not below the belt. It's fair. It's what the jurors said, but lawyers know they're not going anywhere alleging that, the jury.
They let the public know, which is nice.
Yeah, but they're not, the jury did not literally not fulfill their duty because Brian Albert's going to beat me up because he's 20 feet away from me. So that has nothing to do with it.
Let's bring up Mazza Media. He's in the green room. Let's bring him up. What's up, Mazza?
How's it going?
Good. How you doing?
Is the no hat thing a new trend now, Mike? Is this the new?
As long as
look to do?
Yeah, I mean, it's, you know what? I have more time lately.
Okay.
I can go get my hair cut. I don't like if as long as my hair is neat, I'll go without a
Yeah.
hat. My
Right,
girlfriend's been begging me to do it, but I'm like, my hair is too long. It's just too long to take off the hat. But I've been getting a regular haircut. I got more time. I'm not doing as many dogs. I'm trying to cut back a little bit. And it's
Yep.
summertime. It slows
Yeah.
down. We'll see.
Yeah.
So in September, I could have the hat back.
Okay. That makes sense. It is kind of hot right now. Your head would sweat. So anytime I wear a hat this time of year, my head's like drenching and all that. So I
Oh
like
yeah.
the look. You look great. You look awesome. Attorney Mark Bederow is obviously a great central air because he's wearing a hoodie right now. So he looks great.
It's it's awful. You know, all day around here, it's in the 90s. It's humid, but for some reason in my house, the later in the day it gets because I like it cold, and I'd rather wear like long sleeves and have the air conditioning blasting and a fan blasting. I'm one of those people who, when I sleep, I want to like Vornado at full blast, 3 inches
I'm
from my
with you.
face
I'm the
in the
same
middle of
way.
winter. In the middle of winter, and I'd rather wear 8 blankets and still have that.
Yeah,
That may
That's
drive
awesome.
other people in the home crazy, but that's not a conversation for this podcast.
I mean, it's funny too because with central, I have central air. It's like different parts of the house get different. I'm in the coolest room in the house by far.
Oh.
This is like the chill room. Like you get in here, it's like friggin' ice cube. But you know, not every room is the same. And with central air, I find, anyways. I don't know about you, Mark, but that's what I found.
You know, we have like different zones, so you can
Yeah.
even like program it in a different way, but it doesn't matter. Where I am right now, it's blasting cold. I like it, but I just, you know, gotta go long sleeve.
Yeah, that works. Well, I'll tell you where it's hot. It's hot at Canton Select Board meetings, and it was extremely hot last night. And I did not appreciate the fact that Canton police officer grabbed Jennifer O'Donnell the way he did. And there was a lot of debate in my comment section. A lot of the people that were debating it, they didn't appear to be your traditional anti-Karen Reed trolls. They might have just been people that were coming across it. A lot of them weren't my followers that were making these comments. My followers were kind of, digging back at him. But basically, the cop grabbed her, and someone tried to say to me, "Well, they grabbed her shirt and not her." I'm like, my man, that's the same thing. There's no difference. That's literally you're grabbing somebody, even if you're not physically grabbing their arm, but you're grabbing their shirt. What's the difference? And this was so ridiculous. And some people were trying to justify it. Well, Jen just should have left like she was told. Either way, that doesn't give the officer in this particular case justification to grab somebody. I mean, you look at the way policing's been in this country over the past few years. It's been a pretty hot topic. And anytime you're going to grab someone and try to physically remove them. I mean, like I said in my post last night, this was a select board meeting. It's a gathering of people in town. This isn't a bar gathering or a some kind of dive bar or a concert or Woodstock or some kind of mosh pit where people are out of control or they're brandishing weapons. And this is a select board meeting in the middle of town hall where anything of any level of violence is probably as least likely to happen as possible. And last night, they walk up to Jennifer O'Donnell because she talked for 20 seconds too long and they wanted to get her thrown out. She stood for her rights, which are her constitutional rights, and she stood her ground. And this officer decided to grab her. He has no right to do that. Someone goes, "They love my eyebrows." Thank you so much. But they decided to grab her arm. And this officer could have done a lot of things. If they wanted to remove her, okay, fine. That's how the select board wants it to be. They want her out, okay, fine. But if you're a police officer, and I'm talking about on the police officer's behalf here too, the last thing you want to do is touch somebody, grab somebody, potentially assault somebody, and put yourself at risk for being sued or fired or any of that. So this officer just overstepped his bounds yesterday and was way the hell out of line and could have tried to de-escalate this situation if he had to say, "Miss O'Donnell, they're asking you to leave. You got to leave." Instead, he starts grabbing her. NBC 10 catches this on her camera, and all you see is a woman basically being grabbed by an officer. And then furthermore, someone tried to say that Jen had apparently assaulted the officer, which was not true. The cop's arm was already on her arm at this particular point. And he was yanking her, and she was kind of like trying to keep her balance, basically. And she said this. I heard her say this. Well, not heard her, but online, I saw her say this, and I watched it back, and she's right. She actually is trying to keep her balance. So this Canton Police Department has obviously targeted her. They pulled her over recently. They've been, when I was there, it's a hostile environment. These townspeople have had enough of this. And what do you see right before everybody's eyes is a citizen who's been nothing but civil, nothing but diplomatic with the select board for well over a year now. And basically they're trying to throw her out physically. Just if she doesn't want to leave, then maybe not throw her out. She wasn't all that unruly anyway. Some people are trying to say she was. I disagree. I think she was just trying to get her point across. It's been a hostile environment. The select board has not been very endearing to the people of this particular town. They've had to fight for everything and basically have had to eat crow a lot because the select board just won't do anything for them. They put the citizens of this town in this situation over and over and over again. They have not answered the call. They've been blatantly negligent, and the townspeople are just sick of it. But like I said, touching Jen like that, totally uncalled for. There's no business doing that. You don't put your hand on a woman. It's not like she was physically unruly. I read somewhere, I'm not sure if it's a state law, but basically a cop really doesn't have an opportunity to grab you unless you're physically out of control and you're a physical threat to somebody or someone. And I don't think that was the case here at all. It's obviously that Jen was just trying to get her point across. And they don't like to hear Jen talk because when Jen talks, she tells the truth. She says the things they don't want to listen to. And the same can be said for Rita and Kathleen Howley, Sean Colburn, and a host of other people.
It's really unfortunate that it's gotten to that point where I just don't understand to the select board, like the lack of leadership, the fact that they just sit there and say your public comment, you can make it, but we're not going to respond.
Yeah.
Like that can be fine in most meetings, but this isn't like most meetings. This is your town is in crisis. You need to start responding. Like they responded like in the worst way, the way that they treat the people with the timer and just the whole demeanor of it. It just, even that Trish Boyden, I'm like, I don't get it. I really don't get it at this point.
Oh, it's sickening. It's sickening to watch. I mean, I had to glare on. We didn't get our show off the air in time, and everyone's like, "Oh, the select board's on." I'm like, "Well, might as well throw it on." I don't want to take any views away from you, Mike, but I'm like, "Well, since we're still on, we'll tune in." As soon as we tuned in, that was all underway, and I sat there and I wasn't reacting because I was just so disgusted because it just makes me sick to see people. When I was at the town meeting 2 weeks ago, I walked out in that hallway after everybody was either thrown out or walked out, and they were all gathered in the hallway. And I made a comment to every single one of them. I said, I am truly sorry that you guys have to deal with this. I am truly sorry. Like, I felt like I had to apologize for the Canton Select Board because it was so sickening to watch what they go through. And just the way they don't, it's not even that they don't listen to the town. They won't even come to the table with the town and actually have a discussion about anything that they're talking about. And they try to email them and they say, well, send us an email. And you get people in the town that have sent multiple emails that they oftentimes either don't respond to or do vaguely if they respond at all. I don't know. I can't speak for the town, but it just on and on this thing goes. And this town's going to have to just keep fighting, obviously, and try to get people out of there and get new people in because it's just sickening to watch these people have to go through this constantly. And it's even more sick to see a woman grabbed by a cop by her arm like that. This is not the 1960s anymore. When your teacher would grab a kid and physically throw him out of the classroom. She's a grown woman. He's a police officer. He's a grown man. Just speak with her and tell her why she needs to leave and do what you got to do that way. And that's that. But the Canton Police Department are not the personal militia for the Canton Select Board to say, hey, get them out of there. Like it's the Roman Empire or something like that. Take them to the back to the gladiator room or something. It's just sickening to watch these people.
You could feed them to the lions, I think.
Yeah. It's a select board meeting, for goodness sake, a select board meeting. And this cop's like, oh yeah, I better grab her by the arm to get her out of here because it's
creepy.
Yeah.
It's a weird. What is up with these dudes in Canton that like to touch women in public? Like there's that other dude outside the pizza shop. One of the Big Albert kids there.
Yeah.
Touching Meredith there. That was just so freaky.
Sam Nagel.
Sam
Nagel. Yeah.
And this cop, it's just like, I want to ask Mark too about this police chief. Her contract is up. The select board is deciding. I don't know. Did they make the decision? I don't even know. Like, do we know? Have they made the decision? It seems like they have, but we don't even know that they're basically floating out there that they're going to do a 1-year extension of her contract.
Yes, 2
And a
weeks
lot
ago.
of the
That's
citizens
yeah.
want her to be gone. They want to replace her
Well,
with an outsider. Does that seem sensible to you? Like, considering what we've seen?
I mean, the analogy I would draw, and Mazza, you'll appreciate this, is sports. The 1-year extension is the hold your nose. What are we doing? You're basically saying we don't know what the hell we're doing, and we obviously are not confirming. We have a lot of confidence in her, but in the same token, they don't want to give in to the pink people or whatever, and just because you say she has to go. And to me, it sounds like let's just try to weather the storm, kick the can down the road, and deal with it later. But the reality is, if this police chief has been an issue for some period of time, why wouldn't they, behind the scenes, assuming they were, a good select board and not full of, at least the people that are on it, wouldn't they have been already looking for other candidates? Shouldn't they have already interviewed? Maybe they did. I don't know. Do due diligence on other candidates. And it sounds like they probably haven't, if this is the way they're doing it. So,
that you know what? I'm so glad. Say that again. I want to repeat that because that's so sensible, and I guarantee they haven't done this.
What you would do, I mean, you see this in every town. You see it with like school boards, select boards, whatever. You have somebody at the top of the mountain that a lot of people have no confidence in. A lot of the public doesn't want them there for whatever reason. They're not qualified. They don't have leadership traits. Just there's no confidence. Clearly, this Rafferty appears to be one of those. So wouldn't it make sense to do your due diligence while you're figuring out to say, maybe there are alternatives? But that doesn't mean we have to fire her and say, beat it. But why wouldn't you start the process of, let's take applications? Are there other people? Do due diligence. Maybe there is somebody better. But now they're in a situation where if they probably didn't do that, they don't have an alternative. So you can't just fire her, because what if there's nobody to take her place? So what do? You do the dreaded 1-year renewal, which, in the sports world, what happens to a manager or coach when they get offered 1 year? They say, see you later, I'm out of here.
Yep.
You're telling me you're just kicking the can down the road. But, in this place, I don't think they probably have any real idea or have thought out what they're doing. I mean, look at the people on the select board and look how they conduct their meetings and behave. So outside of the meetings too, look at the people they put on the select board, for Christ's sakes, at least in one instance. So, I mean, honestly, this town, it looks gone. I mean, to most sensible people. And I just laugh because man, growing up, I thought Canton was like some nice, exclusive, just Dunkin' Donuts headquarters and nice people. I had no idea that it was, just like, it feels like an outpost of like the Southie mob is what it feels like.
Short house.
Oh, it's so true. It's so true. Some people actually disagreed with me when I was standing up on behalf of Jennifer O'Donnell in the chat. I was reading through some of the comments. Some people were telling me I was wrong. Hey, if you agree with that, I mean, that's your call. But at the same time, I don't see why they're physically enabled to be able to touch her like that and grab her arm like that.
What was their pushback? What were they saying in the chat?
Mazza, you're wrong. Mazza, calm down. I disagree. Those are just simple statements like that. But I wanted to kind of just make note of it, that I don't see how it's disagreeable when you endorse a woman getting grabbed by her arm like that, and they try to walk her out like she's a small child. I mean, I don't understand the logic in that. I really don't. Like I said, if I was the cop, I wouldn't put my hands on anybody because I don't want to be liable for potential suits. That's just my particular opinion. So I'm speaking from the cop's perspective as well. There's that. Welcome back, Mr. Attorney Mark Bederow is back.
Got some really bad internet in my house, apparently.
Yeah,
Sorry
we can tell. It's funny how we can see the screen. It breaks up a little bit. You can tell a little bit,
okay.
but we'll make do. You're doing fine.
We'll make do. I'm here. Yeah.
Yeah.
Again, they're criticizing the drapes. You know what the problem is? They're kind of behind a shelf, and I don't want them going all the way behind. So sorry about the drapes.
Don't let these fools get you with
It's okay.
They're
I don't mind.
idiots.
Listen, I'll
The
take
idiots
interior.
criticizing. I just, at this
Okay.
point, I feel like the critics are just like, they just say stupid shit. Like they're fans
get-
too. They get up, they like try to nitpick. It's like, come on.
I get much worse things said about me than my drapes.
Yeah.
It's okay.
You're giving them so much. What are they giving to you? They're upset about your drapes.
They're upset about
Give me a
my
break.
drapes.
You guys owe Bederow. You give him criticism for his drapes.
Yeah, leave the drapes alone.
They
Jeez.
came with the house.
Pick
I
on
did
Mike's
not-
background and stuff.
I like the drapes. I think they look great.
I appreciate that. Thank you.
Yeah.
Mm.
I think your background's perfect. We get some New York. We're looking at some New York right now.
Well,
What's in the background here?
suburbia. You're looking
Suburbia.
at trees, houses, and that kind of thing. Yeah.
Nice.
Yeah.
All right, we got some more questions that have come in. I'm just taking a look at some of them. What's this one? This is a question. It's a comment that they're saying that you posted a link to case law.
Yeah. So where do we even begin with this? So a lot of people in this thing with what's going on, obviously with apparently the latest argument that there could be 12 jurors who are saying, we voted not guilty. What do we do? So there is a Supreme Court of the United States case from 2012, which is kind of similar, but if you actually read it carefully, not really. But so some people were saying this is going to be a problem. That's fair analysis. You look at it and at first blush, you might say that this case is a hurdle for the defense. But what set it off is Coffindaffer again. She put up a very snarky tweet about, it's case law, people. And of course, she doesn't mention the name of the case. And she put a screenshot of one paragraph from the case. There's no citation. There's no way for any normal person to actually look it up and read it. And so, sometimes I get a little crusade-like, said, if they're going to file this motion, they're going to have to deal with case law that could be adverse to what it is. So you have to look it up. So you look it up, and it's 12 pages, which is actually pretty short for the Supreme Court. But basically, it was a case in Arkansas, which, as you can imagine, it's kind of an ass backwards case. It came from Arkansas. They're not exactly known for being favorable to defendants' due process rights than perhaps other places. But in any event, the guy in that case was charged with murder and one count, but there were lesser included offenses of manslaughter and whatever, or different degrees of murder. And, the judge told them, you got to go down the list. You got to, if not this, not that. So what happened in that case, and again, different states do it differently, but after 3 or 4 days, the judge in that case essentially said, where are we? What are we doing? Which again, is not how you would do this in most jurisdictions. But in any event, the jury told the judge that we are not guilty on the murder, maybe some other offenses, but we have not reached a decision on something else. So far, it sounds kind of similar to what happened here. So the big distinction is in that case, the judge said, get back in there and deliberate more. Okay. And they did. And eventually they came out and decided, actually, I might have it backwards. Hold on. I'm sorry. Initially, they told the judge, they told the judge initially that we are able to reach a verdict. He didn't ask what it was on the murder count, but they went back and deliberated. And then ultimately they changed their mind and said we couldn't reach an outcome. And the key, what the court said the key is that when they went back and deliberated, that means they could have changed their minds from what you told me previously. Okay. Because you don't know what happens. Jurors can change their minds. The key distinction was the deliberations were not over. And they went back and at that point said, we don't have a verdict on the murder, and they were allowed to retry everything because of that. Of course, in Karen Reed's case, that's total opposite. Deliberations were over, not necessarily by the jury's, they didn't know that necessarily. And because of that, that was their final opinion, according to what you're reading about now. That wasn't said in the courtroom, which is still a problem they're going to have to deal with. But the point is, in Karen Reed's case, the jury was over. They were done. The deliberations were over. In the case that, she posted one snapshot of, she was totally wrong about the distinguishing characteristic, which is whatever the jury told me was going to be their verdict, they did go back to work and it could have changed. Therefore, by not publishing the verdict, we're not going to sit here and play guesswork. So that's a very distinguishing factual circumstance. So I don't think it would be in any way, shape, or form controlling, because when you look at this case that the Supreme Court was talking about, they kept saying about the possibility that they could have changed their mind, that the defendant was wrong because he assumes that the votes reported by the foreperson initially did not change, even though the jury deliberated further. The whole rationale for the holding of the court and allowing the retrial, notwithstanding the judge saying, no, we meant to be done with that count, was that they deliberated further and it could have changed. So that is a major factual distinguishing characteristic that's not present in this case. If that makes any sense. I don't know if it does.
Yeah, it definitely does. I mean, they definitely finished the deliberations. That's a key difference here.
I mean, the difference is if these jurors come forward in Karen Reed's case, they're saying, no, that's our final, we were done. Like we had it.
Done deal.
And that's it. And you just don't know. But in the other case, the court was saying, well, maybe not, because who knows what happened after further deliberations, which is true. You just don't know. But so this case is not what I would call controlling, where it would literally dictate what happens. The other wrinkle is this. There are certain states, and I'm sure Massachusetts is one of these, where they rely on their state constitution to afford a defendant more rights than they would get under the federal constitution. So like New York is a perfect example of this too. A lot of times there are cases where the New York Court of Appeals, which is the highest court in New York, what you would call the Supreme Judicial Court, I think, in Massachusetts, will specifically say, we are aware that the United States Supreme Court says that a defendant only gets this. We're giving more, and we're relying upon the state constitution. Massachusetts would certainly be a jurisdiction where there are times where you would get more rights that are afforded to a defendant than you would get under federal law. And I know in Massachusetts, one of the examples is as it relates to standing to suppress evidence. I know Massachusetts in certain situations gives a criminal defendant the right, standing legally, the right to assert a right about a constitutional bad search that didn't even occur to them. In other words, it wasn't their rights that were necessarily violated. And in certain situations, they're still allowed to get evidence suppressed if the cops violated other people's rights. I'm unaware of that being the law in any other state. Like in New York, it doesn't work that way. It doesn't work that way in most other so-called liberal states. So don't assume that an appellate court, if Canoni doesn't agree with any of this, is necessarily going to not be troubled by the fact that if 12 jurors are going to submit affidavits and testify that this is what happened, that they may not be interested in that. The last point on this, just to add, and I think this is important too, because you see this on the online stuff from some of the zombies and the carnies and the freak shows about, well, it's all hearsay. Of course it's all hearsay. They're not allowed to affirmatively approach the jury and do things. Now, if the jury calls them, they can listen. I suppose they can ask the most basic follow-up questions, but what they're not going to do is send an investigator out there to talk to them, set up an in-person meeting and say, oh, by the way, do you mind if you give me your email address so I can send you an affidavit to sign? Okay, read this and sign it. That's coming. That would come later. And that, if you look at their motion carefully, they asked for the right for the judge to allow them to contact the jurors. And the reason they would do that is to have an investigator speak to them, gather evidence, get affidavits. But they're not there yet because they're not allowed to speak to them. So these people who are laughing at this as, well, it's all hearsay. This is the beginning. Okay. This is the first step. The next step is to get the affidavits, get sworn allegations, which would get you a hearing, assuming there's a reason, a factual question that has to be analyzed that cannot be defeated basically on the papers, which gets back to what you said earlier, which is then you wait for the DA. How do they respond? Are they going to basically say, who cares? It ought to be done on the papers. They aren't entitled to this relief because, they waive their right. And if that's the case, you know what you're dealing with. You're dealing with people that have no regard for the Constitution, because any prosecutor, they don't have to agree with the ultimate outcome here. But if 12 out of 12 jurors are saying, I swear to God, this is not what we did, and this only happened a week ago, and the next day we called the lawyers, okay, and we were talking amongst ourselves saying, I can't believe this. If you're not even concerned about justice in that regard, and you're okay with saying we can retry her for murder, you picked the wrong profession, and you should resign and go find something else to do and just let this play out, let it be heard, and then, look to the judge and see what she does, assuming she's the judge who presides over this, because if I'm them, I'm asking for a new judge because you're a witness.
Bingo. That's amazing. Yeah, some people like the drapes. KMR says we love the drapes. No hanging towel fans here.
Oh
We
my
see what you
God.
did there. That was a good one.
I
It ain't Wendy's world.
I have to tell you something. So the other day in the mail, son orders, like graphic boxer shorts. Okay. And he orders like 3 pairs of South Park shorts. Now, 3 months ago, I would have had no clue. But there's a pair that
Chief
is
Wiggum?
purple with a face and the hat. And I said, oh my God, that's the towel, isn't it?
Well,
He says,
the
that's
towel.
yes.
That's the
Now, he
towel.
doesn't know about our lunatic towel. But
That was Chief Wiggum. Is that South Park too?
no, that's the Simpsons. No, that's the police
That's the
chief
Simpsons.
from the
Oh, yeah.
Simpsons.
See, I'm getting mixed up.
Yeah,
Yeah.
boys, what are we
Yeah.
doing?
So let's, your son got the towel.
He got a pair of boxer shorts that I knew was the towel, and I would not have known that. So
What is that character about? What is that all about?
I think he's just like a pot smoking thing. I'm told. I don't know.
Oh,
I don't know. I haven't watched South Park in so long, and of course, my favorite part is the Chewbacca defense.
no idea.
No, you don't know the Chewbacca defense?
No, I just don't. I've watched South Park maybe a handful of times. I don't know.
You should Google when this is over the Chewbacca defense. Where,
Yeah, I'll check it out.
Chewbacca was a Wookiee, and Mazza, you're no sound. He knows the Chewbacca defense.
Yeah, this is
Dude.
Chewbacca. This does not make sense, ladies and gentlemen.
You must have quit. Now, why would Chewbacca, a Wookiee? It's Google. It's a 5-minute.
I'll
This
check
does
it
not
out.
make
I'll check
sense.
it out.
And then you watch.
Well, I'll know what you guys are talking about.
Is it? I guess it must be Cartman. He's like, this guy's good. This guy's good. And they have the lawyer doing it. It's like a caricature of Johnny Cochran. It's funny.
Amazing.
It's
This
worth
does
a
not
watch.
make sense. Yeah, Towley.
What does that have to do
I
with
like the
anything?
South Park.
Absolutely nothing.
Yeah, they did some good cannabis parodies about like how shady that industry is, the Integrity Farms. I like that stuff. Like I watched some of it. It was
The
very good
Chewbacca
parody.
defense, though, has become a term of art in culture, in legal culture, when you have nothing and you're just throwing crap at the wall and trying to confuse. You just throw out, they call it, you've got nothing left but the Chewbacca defense.
Classic episode.
Yeah.
This is Chewbacca. This does not make sense.
Really, I love these ones. They throw down money and then they have a question, and then they said another comment because I didn't ask the question, and they want to know if they can go out. Like, come on, come on. Oh my God. I just sometimes I laugh. I have to laugh at because I don't even know what she's talking about. Suzanne says Bev impounded the jurors' names, but the Mass State Police has them. Could the Mass State Police approach and threaten the jurors, do drive-bys? There was another question too about this was if any of the jurors contacted the Commonwealth, does the Commonwealth have to report it?
No. Hang on one second. What? For 2 seconds. Somebody wants to say hello.
Oh, hello.
Okay, I thought the boxer shorts were coming on here. I'm like, you don't have to do this.
Hello.
Hey,
All right, say hello. Okay.
How you doing?
hello.
Good.
Okay.
Do you want to say anything to everyone watching tonight? Are you missing your dad? Do you want us to get off the show early?
No, she wants me in here. Are you kidding? This way I can't drive her nuts.
Then
All right.
why-
Future attorney right there.
All right. Okay.
You got a deal? Cute.
So, yeah, they have the list. I mean, somebody in charge of security has the list. Now, if it's impounded, which I'm guessing is just Massachusetts speak for sealed in what I think most places would call it. No one is supposed to access it. It's, under so-called lock and key, all of that. But what does that really mean? Nothing. If somebody has access to it, they have access to it. I certainly hope they wouldn't do that, but who knows? But if the jurors want to contact anyone on their own, it's not like you're not allowed to listen. They have a First Amendment right to say whatever they want. And I think what ought to be concerning here to the DA in retrying the case is it appears so far that at least 2 jurors have deliberately, intentionally reached out to the defense. Another 2 have kind of, sort of reached out to the defense, but maybe are a little more concerned about it. And one of the ones who has had direct contact with the defense has essentially said, guarantee you 12 out of 12 are going to tell you the same thing. So, I mean, this is as pretty much unprecedented as you'll ever see. I mean, I've never heard of anything like this. This is, in a case that's full of just crazy, this is next level nuts.
Par for the course in this particular situation,
Yeah.
considering how outrageous the framing and the cover-ups have been, that it would make sense that this particular case would end in this amount of controversy. That's for sure. This is absolutely outrageous. And honestly, a lot of us were fearing something like this. We didn't maybe expect it to come in this form, but
It's so
we
weird.
figured there might be some kind of outrageousness. Yeah.
It's so weird because I do remember talking in the beginning when this whole thing with the verdict sheet came up and the instructions that this could happen. But I don't think anybody seriously thought a week later that the so-called non-verdict may have in fact been a very substantial partial verdict. It's crazy.
There's a question.
No one's ever seen this.
There's a question here that says it's for Mark, but I'm going to answer it because I'm the one who knows more about FOIAs in Massachusetts. You don't know about this sort of the FOIA, how the process works in Massachusetts. I'm guessing, Mark.
I mean, I'm certainly very familiar with the Freedom of Information Act or law, as they call it in New York, and the feds call it an act. It's probably standard. I mean, you can go ahead and do this if you've done this a lot. The law is probably, I would imagine, almost identical in these 2 states. But yeah, go ahead.
Yeah, I mean, she's asking basically they got Rafferty is denying the FOIA requests about the call that John O'Keefe made. Can she do that? I think she can because it's probably an open case. That's what she's going to say.
Definitely.
But the suggestion of what to do on a FOIA, you take it to the State House. You take it to Tom Galvin. You just Google it. Massachusetts FOIA appeal. You can appeal it. I mean, you're probably not going to get approved, but that's your suggestion. That's appeal it.
The litigation exception is a real thing, and if there is an ongoing case, they are going to deny it on that basis,
Exactly.
and that's not going to get reversed. It's not. That's a real thing.
So, I mean, that's all you can do on FOIA.
But that's a temporary thing too. That's not a forever thing.
And they could say the case is closed. Who knows, right?
No, they can't because there's an open indictment that's not resolved that has an open court appearance. So it's an ongoing legal case. I mean,
Is that a legal case though?
Yep. Yeah, there's litigation. What happens to Karen Reed if she doesn't show up in court on July?
No,
20th?
I'm talking about this guy. This one that they're talking about. This report of drugs. This is not.
Oh, you're talking about
really-
John O'Keefe. Oh, you're
Yeah.
talking about like his investigation or whatever.
So basically, John O'Keefe made a report to Kevin Albert about drug dealing in the neighborhood before he died, and they
Okay.
want the FOIA on that. They want the report. But I think she's going to say it's an open case. But how
That
long
I
is
would
an open
appeal.
case for drug dealing? I mean,
Yeah,
that
no,
what,
I
7
mean,
years? I mean,
Yeah, I would argue that that's a ridiculous interpretation, certainly under this.
that's why
exception.
I would take it to the state house.
Yes, I
Tom
misunderstood
Gavin,
what we were
Secretary of
talking about.
State.
Yeah, no, I would appeal that. Yeah, and usually what you'll do is when they deny it, they have a FOIL request records access officer who's supposed to be the ombudsman. You appeal to them, then they tell you to pound sand 99% of the time, and then you have to get into the whole process. And ultimately, I mean, you could start filing lawsuits and everything if you really want to do it.
And I think the best way too for people who want to do FOIAs, I use a website called Muckrock. It costs money, but they do it for you. Basically, it's a program and it's public, so there's a record of it. That's what I like about it. There's a record of it, and it alerts everyone else. And sometimes Muckrock will pick it up. It's like a website that promotes FOIAs, and they'll if it's a good one, if there's something really noteworthy, you might get on the front of Muckrock. So people, when you want to do FOIAs, you want information how to process it, muckrock.com. That's my suggestion. Makes it easy. It's like the Facebook of FOIA requests. And they got they make sure the email gets to who it's supposed to too. That's what I like about it. You don't have to search for it. You just search for like the police department or whoever you're requesting the info, and it's usually there. There's some other comments too here tonight. Question: do you got anything, Mazza? You haven't spoken in a while.
Not really anything new to add, really, that we haven't already talked about right now. But I'm still just very perturbed by this particular trial. Obviously, that basically you had several counts of 12-0 not guilty verdicts, and basically none of that was brought up over a week ago. It's extremely frustrating, and it just, when many of us have just been suspicious of corruption and cover-ups and framing and all that, then something like this starts to happen where you have jurors going to the defense. So far, at least 4 of them, it's just extremely frustrating to have to sit here for all of us, and especially Karen, most importantly, our defense team and her family, obviously, first and foremost. But it's just so sickening because I felt like that jury could come to this very concretely and concisely and come out with like a guilty or not guilty. I didn't think that they would come out guilty at all. I thought there was like a 0% chance of that happening, but I just did not think that this thing they would basically declare not guilty on certain counts. Then all of a sudden we're finding out that, it's a mistrial. What about count 1 and count 3?
They're giving the DA a real mulligan, and they're going to blow it, because the murder charge, even if they're allowed to do it, they shouldn't. It's overcharged. I mean, they shouldn't do any of this.
Yeah.
She shouldn't be charged. She shouldn't be indicted. We've been over that. But if they're going to do it, charging murder is so stupid for so many different reasons. They don't look credible. It mucks up the evidence with all this Aruba nonsense and text messages and other garbage that really doesn't matter. And the DA, if they had a brain, could come in and say, we disagree that the jury voted to acquit her, but Judge, this issue is going to be moot because we're here to announce that we are dismissing the murder charge and we will prosecute on, manslaughter. That would be politically a clean way, or cleaner. None of this is clean with them, but a cleaner way to kind of get out of this mess that they're in. Now, having said that, I expect them to do the exact opposite. I expect them to come in guns a-blazing, arguing against this, saying we have a right to retry her for murder, and we damn well intend to do it because she's guilty and all of that, because they're just, whatever their instinct would tell you that they should do, they tend to do the exact opposite. But they would be doing the DA a favor, the judge would, by dismissing that count. She really would. And if you can't trust them to do it right themselves, that would still be helpful to them. They may not know it, but it would be.
You think judicial misconduct's in play here for any of this?
Judicial misconduct? Not yet. I mean,
Okay.
she may have made a mistake so far. I mean, but that doesn't mean it's misconduct. Judges get reversed all the time. The misconduct allegedly would come into play about what happened during that meeting that she had, which again, I'm not suggesting there was anything bad that occurred, or if they had checked off the boxes that said not guilty and didn't tell anyone, that would be real bad. That's hard to believe. I think you would know that. I think one of these jurors would have said, and the foreman checked off the box. What happened? So is there any misconduct here? I don't see it yet. And I don't know that there would be, but that doesn't mean that she didn't make legal error that requires entering, not guilty verdicts on the 2 counts either. It doesn't have to be a situation of misconduct to favor an outcome that ought to be acquittals on those 2 counts.
Right.
This is a question that came in about this. If Bev is the one to decide if the jurors can be heard or testify to the results, or would that be a different judge?
Right now it's her. What I'm suggesting is what I would do if I were Karen Reed's lawyer is to basically tell the judge, before you rule on this, there's something we need to let you know. First things first, we need permission to gather evidence from this judge. Okay, how do you say no at this point? I've got evidence that 12 jurors are all saying something screwed up. Get affidavits. Here we go. Now we have real evidence. Then I would, you get a hearing and you say, Judge, we need you to know, we need another judge to determine whether there will even be a hearing. You can't make that decision because it is our intent to call you as a witness at that hearing. And that could create an actual or apparent conflict if you get to determine whether a hearing should be granted, because we're telling you now, we believe you're going to be a witness. So at that point, I would move to have her, have this heard in front of another judge. And what happens if she's a witness and you have lawyers on behalf of Karen Reed cross-examining her in a way where they don't believe her? Now, how can that judge sit in judgment over Karen Reed at a retrial if her so-called scummy lawyers, I'm rolling my eyes, are, aggressively coming after her? What if the jurors have testimony that's different than what the judge says about that meeting? Doesn't even have to be about, oh my God, we told the judge about our verdict. No, we didn't. It can be, what if there were jurors who were really upset and the judge's position was, no, it was talking about cookies and donuts and thank you for your service, and everybody was happy and we all had a group hug and they left. You don't know.
Yeah.
Oh no, she should not be the judge sitting over this. Especially the defense also is going to argue that you, judge, made a mistake by not handling this right and giving us an opportunity to talk, and we're criticizing your conduct. And for all these reasons, and for the reasons we raised previously, last year, we think this ought to be heard in front of another judge. And if she denies that and then denies a hearing, all she's doing is making the defense motion to remove her as judge for a retrial down the line that much stronger. So this is a 2-for-1, the way I look at it. If I'm her lawyer, that's what I'm doing. And by the way, that can get really hot. That can get really nasty. It doesn't have to, but people get upset. But the reality is, if you look at these 2 lawyers, do you really think they're afraid of doing that? I don't think so.
Question for you. If Auntie Bev was removed as judge of the second trial, and the second trial took place in any other county in Massachusetts before Norfolk County, does that ensure that the judge that's selected is not a Norfolk County judge, but a judge from the respective county that the second trial is moved to?
No.
Okay.
Yeah, be Norfolk County.
You can't literally escape the powers that be, is my understanding. And, that's something I'll definitely verify. Different states may have different rules with this too. But normally, based on my experience, what would happen is the judge would travel the same way the prosecutor travels, unless they don't want to for some reason. Now, she may not want.
The only time that changes,
she may not want to stay in Springfield for a month.
The only time that would change is like if the AG said we're going to do a special prosecutor, or the
Okay.
DA, like they did with Bello, right? Like so.
Right, but that's not going to impact the judge, though.
Yeah.
Okay.
And the reality is, look, I don't know who the other judges are in Norfolk County. I don't know what that does or doesn't do for what the defense thinks in terms of, is that a good thing? Is it a bad thing? Is it a jury trial? Is it a bench trial? You know, based on this. But it's pretty clear and seems obvious, I think, to anyone who's watching, that they would feel much better if they had a legitimate basis to have her removed. And it doesn't have to be nasty, by the way. I mean,
Yeah.
Look, I'm not suggesting it by any stretch that she's corrupt. But you know, there are some alleged entanglements in this. There are some behavioral issues that occurred at the trial. There were some kind of bizarre rulings. There is this complete snafu with this non-verdict or verdict or whatever it is. And then you just have the gratuitous private conference that she had right after, which probably 99% of the time is about nothing other than thank you for your service. But given what's going on now, and you have multiple jurors saying we were immediately upset, well, it becomes a really important issue to know what happened in that meeting with the judge. And by the way, if you're the DA and you're going to fight this to the death, you may want the judge to be a witness too. Because if the judge's position is nothing happened in that meeting, right? Nothing weird at all. Then if you're the DA, don't you want that testimony from her in front of another judge?
We have some questions about this. Can the judge refuse to testify is one. And the second thing is, what happens if all the jurors don't come back? Like what happens if one juror says, I'm not coming back to that court. I'm done with you guys.
Well, you subpoena them. There's no post jury service subpoena exception. The question is whether the judge grants a hearing. Okay, if there's no hearing, then they have no subpoena power. I mean, the subpoenas would all be quashed because you're subpoenaing them for a purpose regarding an issue that's not before the court, and I'm not allowing you to do that. But if there is a hearing on this issue over the verdict or non-verdict, then who is anybody to say that every single juror is not a material witness in that proceeding, as well as the judge, as well as potentially Alan Jackson, and certainly Yannetti, because of the conversations he had with the intermediaries and all of that. Who are those people? What did they tell you? Is that, I mean, so yeah, I mean, look, that's why they brought in Weinberg. Clearly, they can't, they recognize if we're going to be witnesses potentially at a hearing, we can't do this, or we can't file the motion if we know that we're going to be witnesses. So they're preparing for that possibility, and they did the right thing. They had to add another lawyer to the team for that purpose, and they brought in another big gun, and that's what you want to see.
Comment: I loved you, Varney. Is it like be that show? Were you on of the Varney guy from Fox Business? Maybe, I don't know what's his comment. No.
I don't think I've ever.
Maybe Jim Varney, who played Ernest in all those movies.
I don't know him. I've been on Fox News many, many times over the years, but I don't think ever with Varney.
Okay. I have no idea. Sometimes people make like me. We type too quickly and it doesn't come out correctly. Maybe that's it. I appreciate the comment. Anyways, Jennifer, thank you so much. People have been very generous tonight. I want to thank all the super chats, like people gifting memberships. Someone just gave $49. Romy, thank you so much. You guys are amazing. Thank you so much. This keeps coming up. They're asking about this. It's a constant discussion on Twitter too about this juror notebooks. Yeah. Are they safe at night?
Well, there's either one of two things. I'm not entirely. They're either under lock and key as part of the secure and sealed court file, or they may very well be destroyed. They're not evidence. Remember, they're meant to be as aids to refresh the recollection of jurors. So they're not necessarily the kind of thing that even need to be preserved. I don't know where they are. The jurors don't get to take them home. That I can tell you. No way. But, court usually maintains in the court file evidence. This is not evidence.
Do you think they should be concerned though that this is the rumor mill coming around. People are worried that somebody in the court is reading what the jurors wrote in their notebooks to try to get them thrown off the jury. That's the theory here that's been going around a lot.
That
How do
points
you
in the
throw-
direction of the bailiffs.
But that ship kind of sailed, right? How do you get
Yeah.
somebody thrown off the jury when the jury is over? I mean, I don't. I mean, that's like putting someone on double secret probation. I don't know what that means.
Yeah,
Animal House reference? No, Mass? No.
I know that one. I know that
No.
one.
No, I'm not. I don't want to watch
I
that
know
movie.
it.
Wait a
Well, I even know his
pop
name.
culture
That was
guy and you're
Dean
not-
Wormer.
Oh my
Dean
God.
Wormer.
What's his
Right?
name?
Dean
Animal
Wormer.
House?
I know that one. Yeah.
I've seen it once. Yeah,
Oh
I've seen
my-
it one time.
Oh,
No,
food
the
fight.
whole-
Food fight.
when the Germans invaded Pearl Harbor, let him go. He's on a roll.
Yeah, I remember that part. Yeah, yeah.
Fat, drunk, and stupid is no way to go through life, son.
Oh.
No, I mean, this is.
There's so many good lines in that
Oh, I'm
movie.
dating
Twisted
myself.
Sister did all their videos based on that guy from Animal House, the drill instructor guy.
Yeah.
Guy with the horse.
Yep.
He was brought in, right? He was the guy that was brought in to crack down.
Yep.
That was a great movie, Animal House. See that
That's Belushi at his prime.
you definitely. He was great. He's smashing his head. Remember, he's trying to cheer everyone up. Remember that one?
Yep.
Isn't he like?
Yes.
Yeah, that's the food fight.
That's the
The
food
Yeah.
food
fight.
fight scene.
Yeah.
Yep.
That
Kevin
was a good
Bacon was
movie.
in that movie, wasn't he?
Yes,
Yes.
Thank
Yeah.
you, sir. May I have
one of the
another?
military guys or
Yes.
something.
You're right. Yeah.
Donald Sutherland,
Oh
Yep,
wow,
yep.
yeah,
kind of sneaky in that movie. Not one of the,
Maine, yeah.
they wore that helmet, like that almost like biker Nazi helmet kind of thing. Not that he was a Nazi, but like that kind of like steel
Yeah.
metal
Yeah.
biker helmet. Yeah.
Here's one. How soon should we expect Bev to answer defense motion?
Well, I got to tell you, all of this is pathetic that it's now been several days and nothing has been heard from her other than securing the jurors' information, which, by the way, that nothing wrong with that. That does not preclude letting the defense speak to the jurors. But most judges, in my experience, after a case like this, with an appearance coming up on July 22nd, and then a bombshell motion gets dumped in between, would immediately summon the parties and say, okay, I have this motion. Before I do anything, I'm setting a schedule for the DA to respond by this date. And I expect the parties to be prepared on July 22nd to brief on what the hell are we supposed to do next. And to basically say and do nothing is doing a disservice to everyone in this process. And, it's like, a perfect example, and this has nothing to do with politics before anybody bites my head off. Okay. In the Trump trial in Manhattan, it doesn't matter what side you're on. Let's talk about the trial. Stuff was going on back and forth between the parties. It's obviously a hot, heavily contested case. And the court in that case was as up to date, issuing orders, responding, setting schedules, all the time, keeping ahead of everything as much as you could to just try to keep everything moving and get this thing resolved however it's going to get resolved. And this thing just seems to be flailing around because it's summer in Massachusetts and the Cape is here and whatnot.
Down the Cape.
And maybe, maybe we don't know. Maybe she has reached out to them, but I feel like you would know that. You would know if there had been any kind of order issued, a scheduling order, or even advancing the court date, or having a phone, a public phone hearing, a virtual appearance that they started doing during COVID all the time. But it appears to be the defense filed a motion. There's no response. The defense supplemented the motion with more bombshell allegations. Everyone remains silent, and you're just waiting for the next shoe to drop. And you all know what it's going to be. It's going to be more jurors, of course, right? Whether it's tomorrow, the next day.
We're already
next-
hearing about one of them. I mean, there was
I
a
mean,
rumored fifth one now, right? Yeah.
It could be 12, just
I
based
know,
on
right?
what you're reading. I mean, it's coming, right? You know that. Or alternatively, maybe if one called the DA and said, oh, that's not really true, you can be sure they would be saying something. But once again, it just feels like the judge is not taking control of the process and letting it flail
Story of
around.
the trial.
And,
Story of the trial.
I mean, why wouldn't you take control of the process, especially when your primary concern is that jurors are going to get outed? The jury is now the story, which you never want, never.
Exactly.
But the facts lead you wherever they lead you. And although she did protect them
Yeah,
by
she's
not,
put you. That's such a good point. She's put a bigger bullseye on the jury the longer she waits, because every single media person in town now wants to talk to a juror about what's
right.
going on
And
here.
there,
So,
and you can, impound, as they say, the jurors, information, but, journalistically, if a juror finds out, if a reporter locates a juror, are they going to, under the canons of journalistic ethics, not attempt to, I mean, that's the interview you
I'm going
want.
to talk to him.
I mean, isn't,
If anyone knows any, hit me up.
okay, the number one interview right now in this
Yeah.
case, bar none, so says the amateur journalist who, that's my nighttime wannabe job, maybe, is the foreperson of the jury. And of course, the most obvious questions are, what the hell happened in that meeting? And why didn't you check the damn box, not guilty? I mean, that to me is like the quintessential question that everybody needs to know or wants to know. They don't need to know. They want to know. And although she did protect them by not releasing their information, which I think is the right thing to do, you are right in the sense she's making the story have further life. It's going to get crazier. I think if she issued a scheduling order to get the DA's position, I mean, what if the DA's position is we don't oppose for the limited purpose of contacting jurors for the purpose of determining whether a hearing is warranted? And then the judge says, okay, I'm going to allow that. Move it along. So maybe by July 22nd, you know what you're doing. Instead, what it feels like is she's on vacation until July 22nd, and we'll deal with it then, and then schedule it for another.
Crab walking
She could
on
be
the
doing,
cape.
Kicking it down the can.
she could be doing all this now and making July
Yeah.
22nd.
If she wanted to protect the jurors,
Listen, July 22nd was ostensibly to determine a new trial date, right? The DA says we want to retry it. Okay. That's not what July 22nd is for anymore. July 22nd now is, what the hell am I doing?
Yeah, what happened with that verdict?
This motion. And what do I do? But why not start that process now? Even under the theory, if there's going to be a retrial, get this resolved quicker. So if there's going to be a retrial, we can, tee it up. Let's go.
What about the fact that when she impounded the jury, she wrote that on the 8th, 2 days ago, of course, and she scheduled that for 10 days, which would expire by the 18th and no later than the 19th, when the hearing's not till the 22nd. Do you make anything of that?
No, because ultimately that's just what the law is, the timing, whatever. The reality is she has to make a decision one way or the other. Am I going to talk to them or not? And again, I don't know how in good conscience, given the allegations made so far, that you can't at least issue an order, that a form of a protective order that says, I'm going to allow the following individuals to communicate with jurors, the lawyers, their investigators, and their employees, nobody else, that you are not going to be allowed to reveal names, race, gender, address, contact info. And of course, as you've seen, the defense has been handling that properly. Juror A, he or she, they're going out of their way to be professional and not out any of these people. But at some point, you have to allow them to do that. And there are even different ways that you can do it. I mean, you could set up secure phone lines to if you don't want them to know who they are. But the key is, at some point, if you're going to let them talk to them, you need, for lack of a better term, the defense needs the broomstick of the Wicked Witch of the West. Those are sworn affidavits from jurors. You need evidence to get a hearing. You're not getting a hearing based on the hearsay. Not that I'm trying to feed the lunatics, but that's not enough. But the lunatics don't understand that they don't have access to getting anything beyond hearsay right now. They're trying to lay the foundation to allow the court to grant them access to the jurors so they can come back with the broomstick and then present it to the great and all-powerful Judge Cannone.
Mike, I gotta roll. I gotta get going. I gotta head out to I got crab walking class at 8:30. So Sensei Bev is teaching the class tonight. So it's just a class I cannot miss. Now I really got martial arts, but I gotta roll. So I'll leave you guys to it, and
See you soon.
that's that. So have a great night. Free Karen Reed. Yeah, I gotta do the martial art. Yeah, I'll like the yeah. You're on mute, Mike. You're on mute. Yeah. You're Mike. You're on mute.
Thank you, Mazza.
No
Have a
problem.
great night.
No problem. No problem. Have a good one. I gotta do martial
care.
arts. So.
See you
I was
later.
gonna say
Take
this
care,
is how
guys.
we do it in wrestling. This is the
Greco.
we,
Yeah, Greco.
we just
yeah.
hands off.
I do all the intercepting fist stuff, so it's all just like that. So Steven Seagal come at you like
You're
that.
scaring me. I'm ready to
Yeah.
go, but you're
I
too
got the
big for
moves,
me.
man. I got the moves.
You like I'd be like up here trying to like get an arm in. I did it the
Oh,
other
yeah,
day to you
exactly.
when I met you. I was like,
Yeah, you did. You
how,
almost
how
took
would
me
I
out.
even try to like get
Yeah.
over on you? I couldn't even. You're a giant.
I saw you in
like,
person for 2
hugging a
seconds. You
tree.
already attempted a takedown on me right away, Mike. I couldn't believe it. I'm like, this guy's my friend, and this guy's already trying to take me down. He's like,
I
see if
just
can
want to
take this
see.
guy
Like,
down.
I don't even know how I'd touch him. Like, I was like, you really probably could take, those. Well, we talked about it.
Right. Yeah.
Exactly.
Exactly.
We were doing the grab acid. It's more like
Right. We're
grab,
grab
like
ass
grab
him.
the shoulder.
Yeah, exactly. You're like, oh my god, we'll be good. Well, of course, we're
I
all
didn't hurt
talking
you.
about
I don't
self-care,
even
but
think I could hurt you if I tried. You were a little mountain.
yeah, I know. I'm a big guy, so 6'5", 250. So there's that. So, all right, gentlemen, have a great night.
Yeah,
Free
take
Karen
care.
Reed. Don't forget to donate to Karen Reed's Defense Fund. I think Nick Rocco's got a popcorn pop-up store going on too, so check that out. And everyone have a great night. I'll probably be on the show again at some point this week, and I'll be in somebody's studio tomorrow night at 8 o'clock. So, I want to plug it or not
You can
plug it?
plug it.
LTL Media. I'll be on that show tomorrow night at
Even
8.
though I heard it, I'm not going to say it. I'm being mean.
Okay,
Go
I
ahead.
already canceled. Yeah.
No, it's funny.
Yeah.
It's just funny how things work out for people.
Yep. It's awesome stuff. So great. All right, I'm out of here, guys. Have a good one.
Take
Have
care.
a good night.
Yep.
I gotta be nice.
Sometimes it's hard, but I don't even know
What
what
is
it's
it?
hard. But sometimes it's hard to be nice.
It is.
I'm not
because
sure.
I like to make jokes and then people get mad. Like it's just like I don't know.
Joking is okay as long
Yeah,
as
it wasn't a good joke though. It wasn't. Yeah.
well, sometimes you take a step back and maybe it's for the better.
I thought myself.
Yeah.
I love Mazza though. Mazza's a good guy.
Yep.
Yeah, I guess. I mean, we talked a lot about the jury tonight. I think we've covered all of it. We've covered the Canton Select Board too. Oh, I know. There was a question that came up that keeps coming up, and I keep forgetting to ask it. My chat even reminded me to ask it tonight about the Canton Nine. You know about the Canton Nine?
I think so, but I want to be clear that we're talking about the same thing. Are we talking
Yep.
about like some of the protesters that
Yes.
got arrested? Okay.
They stood outside Chris Albert's pizza shop
Okay.
with signs, and they have been threatened with charges. It's never gone anywhere. They're still like, they went
What,
to
were
the
they arrested?
magistrate hearing. No, they were summoned.
Okay.
So they basically
for
were
what?
summoned to like a magistrate hearing.
For what? For standing on a public sidewalk
Yeah,
and protesting?
for witness intimidation.
Well, what did they do? I mean, literally, without even
Literally,
the
they
bias
had signs in front of Chris Albert's pizza shop, like not even in front, like maybe
on
like
public
50 yards
street,
down the
right?
street,
Okay,
a
on
public
a
sidewalk.
street, holding
And
signs.
that's all they did. And the
But-
signs might have said some things about Chris Albert. I don't even know what the sign said, honestly, but that's what all they did. They had signs.
You have a First Amendment right to stand in a public street in front of a business and hold a sign and say, I think you're an asshole. I mean, would I do that? No. Is that accomplish anything? Probably not, but I have a right to do it.
Now these people were brought before the magistrate for a hearing, and then they said within like 30 days we'll let you know if we're actually going to charge you. And then now it's been like 6 months or a year or something. I don't know. It's been a long time,
Are
and
any
they're
of these
still
people-
hanging. Like they don't know what's going to happen to them is there a certain length of time where they have to be charged or it gets
Yeah, well,
dropped?
yeah, there's got to be some kind of statute of limitations. I have no idea what it is because I don't even know what they would be charged with. But if they're standing in a public street holding a sign that's not threatening someone, that if you testify, I will beat you up, that's different. That there comes a point that there are
The
certain
problem in the law in Massachusetts, the law is so broad. It says, this is what I got worried about. This is why they got me scared. They said, if you make a witness uncomfortable.
Well, here's the thing. Here's the beauty of America. Whatever Massachusetts law says about that, that isn't worth anything if the First Amendment to the United States Constitution says that ain't the way it is. You can't restrict by state law, you can't lessen a defendant's rights. We talked earlier how state constitution can afford a criminal defendant more protection, but you can't provide less. And if Massachusetts law says you can't do something that makes a witness feel uncomfortable, then I would love to be admitted in Massachusetts and say, sign me up, because you're not just going to get any charges dismissed. You're going to have more fun than that. You are going to have that statute declared unconstitutional and it will be thrown off the books, because if there is a law that says you can't engage in conduct that makes a witness subjectively feel uncomfortable, that is way overbroad. It's going to be something called void for vagueness, which is another First Amendment concept. There's no way that would hold up to constitutional scrutiny. Now, if the statute says if a way in which a reasonable person, knowing that a person is a witness in the case, engages in conduct that a reasonable person would know threatens them if they do this or if they do that, that's different perhaps. But if the law, I'd have to look at the statute, but if the statute
it's a crazy broad statute. And I think Turtle Boy and his attorney are definitely going to
they're gonna
try to get it all thrown out, because that's what he's
great time.
facing too.
Do we know any of these 9 people? Like, are they kind of usual?
Yeah,
people?
I know a lot of them. Yeah, Mike Bradford. It was the one who hit me up on this one. I don't know him that well, but he sent me a message. But I know like a bunch of the women. Yeah, I know. One of them was never even summoned, but they kept threatening that I did an interview with her recently, that they threatened her, but they never actually summoned her, but they summoned the other ones. It's so, and one of them, there was a 17-year-old who I had on the show who was in high school, and they actually dismissed the charges against him.
These charges are never going to get filed because they're so comically, again, I don't know what was on the sign.
Yeah.
The sign says, if you step foot in a courtroom.
No, it was more like, it's probably like, I don't even know. I think it was like free Karen Reed type stuff. You know what I mean? Or like do the right thing, maybe. I don't know what it was.
Quintessential freedom of expression speech. Yeah. And the fact that they just happen to stand in front of Chris Albert's restaurant, which admittedly, if you're him, that sucks. I mean, it sucks for business. It sucks for you. It sucks for your family. Nobody likes that. But that's kind of the whole point as to why protesters protest. It's to agitate and make people uncomfortable, to hopefully, so they say, affect change or whatever. But you can't arrest or charge someone for standing on a public street screaming and yelling that we're doing this. I mean, unless you're going to argue that they are, it's disorderly conduct because they're blocking traffic or something like that. But if they are not making a problem for like people to get by normally, they're not like blocking traffic in the middle of the street without a permit or whatever, they can't get charged for this. That's
crazy.
And if they were, that's borderline lawsuit stuff.
Keep that in mind. Lawsuits.
What I'd really like to do is see the statute that they were cited for in terms of allegedly committing some kind of infraction. And if it really comes down to making someone uncomfortable, I mean, we gotta bring you down to New York City and see what people do on a public street and say every day, or are protesting every day. And you know what? You just get used to it. I mean, there's been case law in New York where you've had people run up in the face of police officers and just scream and yell and say horrible things, really distasteful stuff. but it still doesn't rise necessarily to the level of anything, summonsable or arrestable, because they have a First Amendment right to act like a jerk off. I mean, it is what it is. And I'm not saying these people are that, by the
Yeah.
way, but
You know, it's funny too. Like in Massachusetts, they used to make us do permits for any type of protest back in the day. And so there was always a risk if you didn't get a permit that you could get arrested. But then the Occupy Boston came.
right. And they just got whatever
And
they were
it changed.
They
And you saw, like, because I'm a guy who did a lot of protests, and I always did them without permits. Like there was one time he came up to me on a 420 protest we started on 420,
Yeah, come on.
And the
I'm not
cop comes up to me. I recorded this with my friend, and my friend's a little more colorful. He'll talk a lot. And so the cop's like, "Did you guys organize?" Because they knew they knew that we were the ones that put it out there, that we were the ones who organized the crowd. So they came up to us, "You guys organized this?" And I looked at him. It's 420. Does anyone organize Christmas? This is like Christmas for us. And the cop it's like Christmas, huh? And he just laughed and he turned around. They all got in the cars and they took off. And I said, "That's it, KOP. I told you." Because
it's crazy.
Yeah. But
Permits,
now they don't even ask. They don't
interesting.
care. There's no permits.
They can require you to get a permit as long as a permit is not denied for what they call a content-based reason. You can't deny a permit because I want to protest. I, hate
Exactly.
whatever. And whether, it just happens to be like an ethnic, racial, whatever. If you were going to give someone else that permit. So you could win, a First Amendment type case on, content-based.
And that's happened a bunch of times here.
Yeah. But
like even for some of the worst people, unfortunately. But
you remember the famous cases in Skokie, Illinois, the marching Nazis. I mean, they got a permit. They were allowed to march. They were even in South Boston for years when they wouldn't let gay people go. And then their whole issue.
And us cannabis users, we did on the Common. There was 6 lawsuits against the city of Boston about the event that we as a community held too.
They can require a permit, but they just
they did. The thing is, like, we wanted to be permitted because it was a big event.
Mm-hmm.
We had insurance, we had the whole 9 yards, and there's obviously a whole process you have to go through to make sure you're doing it right on the Boston Common. So we did that. The question is, they wouldn't approve the permit, and why? We knew why. They didn't like it. So
I mean, now you're getting into
everything right.
You're getting into a content-based denial.
Yeah, that's exactly what it was.
You get a First Amendment suit and you win that. You're right, because it's clearly denying speech.
You did it for us every time.
Let someone do something because I disagree with your viewpoint. That is per se, suppression of your First Amendment right to free speech and assembly and all of that kind of stuff. But
that's what kills me about this whole thing. These guys just holding signs.
I've heard them call that. I didn't know what they really did. This is offensive.
It's offensive too that they don't know, that they're freaking out. Someone said, right here, it said, "Mike, it sounded like you're worried." I'm not worried. I was worried at one point back in January. I was freaking out, but I'm not worried about anything anymore. I know that they were just trying to. I have documentation that they were trying to scare me. That's what it was. They wanted me to shut up.
If you're these people, there would be lawyers lining up to take that at either no cost or low cost, solely for the privilege of rubbing their face in it. And not even just getting these people out of the legal mess that they shouldn't be in, and potentially suing for remedy.
Could they sue? Do you think they could sue right now? Just the fact that they've had just the emotional harm and the fact that they were summons, they were brought before them.
I'd wait till it's dismissed and then maybe, but don't kid yourself. It's not.
What if it's never dismissed? What if nothing ever happens a year from now, 2 years from now?
Then it is dismissed because there's statutes of limitations.
Could they sue? Do you think?
Yeah, they could, but I mean, let's not pretend the damages for that would be a lot. It would be symbolic. But from a lawyer's perspective, what you're wanting to do is you're wanting to file motions in a case like this, where you're attacking the statute. It's not even just about these 9 people that are getting screwed. Now you're going
else that happens.
You're taking down the law, which becomes a very big deal. And if this is wrapped into like the same witness intimidation statute that they're using against Aiden, then I'm going to assume, I don't know this, did his lawyer file motions to strike the statute down, both you would say on its face, which means the whole statute is gone.
I believe he did. I believe he did.
or
If he
you-
hasn't, I know he's attending. I think he did actually, and I
Okay,
don't think it
or
went well actually with him, unfortunately.
You could also attack a statute as applied, meaning it's being used in this particular case in a way that the First Amendment doesn't apply, or does apply and provides protection. And of course, in his case, he has the added benefit of being a journalist, which, as you know, is going to trump up even more First Amendment protection, because if a journalist is acting in his capacity as journalist and news gathering, whether you believe in the tactics used or not, if it's legitimate journalistic activity, it doesn't just necessarily translate to witness harassment because it's unpleasant for the people I'm reporting on. Okay. Now, again, there are things that were testified to at this trial, which are probably not even true. Where, one comes to mind where Jennifer McCabe was alleging that she was getting nasty stuff sent to her. You know what I'm talking about, like human fluids,
Whatever it was.
Okay, that's not protected speech, right? That's clearly, I'm not even saying it's true, so I don't credit.
Yeah, I don't think it's true, but
I don't
that's
think
definitely not protected.
But that's not legal. But that's different than someone who's a journalist breaking a case wide open, which he did, and I'm sure would remind everyone at the trial, and saying, I have some very unpleasant questions to ask you, and I'm going to follow you around and shout them out and ask you, and I'm sorry that you feel upset. And this is exactly what happened a couple of weeks ago. I mean, he, according to him, when there's no reason to doubt this, was in Canton to test out this ridiculous Hill theory for Apple Watches, which to me, I've had an Apple Watch for 8 years or whatever. It sounded stupid. And that's why he was there. And I decided to go eat. And yeah, it's next to Chris Albert's restaurant. That's unfortunate for Chris Albert. But, and they're saying, what are you doing here? You don't belong here. Says who? Says the
Sounds like xenophobia to me. That sounds
says
like
the select board.
Yeah.
Not the select board, man. The select board. He speaks for,
Yeah. He speaks in the town.
So, I mean, according to him, I'll kick your ass if I could, I would. And so, yeah, I mean, it circles back to what we talked about earlier. Somebody said, hold on, that they sent the statutes.
Yeah, they sent the statutes over.
I'm curious. Do we have like a few minutes to look at this? Because this is unbelievable.
If you want to.
Yeah. How did they send it? In what way?
I don't know. Probably Twitter, I'm guessing.
Not yet.
Yeah. She could be on Facebook. She's on Facebook too. I don't know.
Somebody was in the chat complaining about Alec Baldwin's lawyer. Is it? I know him pretty well, actually. That's a conversation for another day. But I don't have any. If anybody sent me, am I looking at the wrong email account? I don't think so. You know what? What is the statute? I could just Google it. Maybe it'll be quicker.
I don't even. Yeah.
I don't know. But
We'd
if
have
somebody
to
has
look
it,
in the chat. Let's see.
I mean, this is really fascinating to me, because if it just simply says making somebody feel upset, that is so blatantly unconstitutional. I mean, like laughably so.
I got one more question for you. So it said, how do you think this jury situation will turn out?
It's hard to say. I mean, to me, right now, you have really serious allegations that are heading down the path where I think there ought to be a hearing, but it's still premature because you're not getting a hearing on lawyers submitting, I was told this, without more. So there's a real process here. The judge has got to allow them the right to gather that evidence. They have made a good faith basis to demonstrate there's something going on here. It would be unconscionable for her to just say, I'm not listening. The DA has to respond, obviously, to the defense motion. Their response is going to be very telling and could be influential to the judge. If they basically say this is serious and maybe we should do this because these allegations are serious, that might make her more willing to say, okay, let's loosen up the jurors and let's let them gather the evidence and have a hearing. Then the question is, does the DA or the judge start making, somebody sent it to me. Does the DA or judge start arguing, this was waived and whatnot? To me, There's a lot of things that favor the defense here, with one caveat. Nobody in the court system likes undoing a jury's work. It can be dangerous. You don't want to set bad precedent that it's okay to just haul jurors in. But there are a few things in this case which I think are really unique. Number one, the jurors are the ones instigating this process. We're instituting, not instigating. That's not fair. My point is, you never hear of the jury being the ones who feel so compelled to reach out to say, this isn't right. And if right now we have apparently four of them that are to some degree on record as doing that. There's word that maybe there's a fifth, but until that happens, who knows? But that's 33% of the jury is already saying this is screwed up. I wouldn't dismiss that out of hand. One of those jurors is saying to a man and woman, we're 12 out of 12 on this, and I'm confident we're like, you're going to hear this from everyone. That's troubling. The other thing that favors the defense in this case is it happened right away. I think it happened like a day or two after. This is not 6 months later. I've had time to think about this, and I don't like it. I read the newspapers, and I changed my mind. This reeks of, and 3 or 4 people within a matter of days on their own doing this has an indicia of truthfulness, an indicia of reliability, an indicia that something is not right. So how do you not err at a minimum on the side of caution because you're concerned that what if this woman was acquitted of murder and this DA is saying, I want to retry her for something she was acquitted? There's no harm in saying, I'm going to let you gather the evidence to try to convince me you're going to get a hearing. Now you present her with that evidence. There's no harm in saying, let's have a hearing. Now, you don't want jurors to testify. I get it. So you know what? Turn the camera off, just like you did with the kids. No cameras. No one's complaining. Okay. Well, maybe some will, but make accommodations. Okay. Do it off TV, whatever. And then let that evidence flesh itself out. And then if it turns out that 12 credible jurors are all saying this, now the judge, whether it's Canoni or whoever, has a really hard decision about what to do, because unless the DA at that point says, fine, we're just going to dismiss it, you don't even have to rule on this, maybe that's their way to keep the judge. Maybe the DA is smarter than we think. I don't think they are, but if you're listening today, here's what I would do if I were you. Just concede, dismiss the murder charge. Now, that doesn't affect the third count. I get it. But if you concede those 2 charges, you're not getting her off the case. No chance, right? Maybe the DA wants her on more than wants the murder charge. And to be honest with you, I don't think any of these charges are ever going to stick, and I think they're all misguided. But the manslaughter one is at least not, the murder one doesn't pass the laugh test. The manslaughter one is just stupid, but at least, it's not as bad. All right, I'm looking at this statute real fast. Give me 1 sec, because this.
All right, I'm going to read a couple comments out too.
Yeah.
They want, the audience now wants us to get you some Young Jerk swag. And they're making contributions to help it. We can handle that.
The hoodies, are they thin or thick?
What, the sweatshirts and stuff?
Yeah.
I don't even know. I gotta order them. I don't even. It's funny because I had
get away with a thin one in the summer.
You want a thin one?
Inside, like not outside. Yeah, like this thing is like.
Yeah, I don't like. See, I got this guy who prints on demand. He's like an artist. He's really good. I'm gonna make an order for him. He actually like all the ones we sold out. But then I have this other company that does it like on print on demand, and I haven't even ordered this shit. I don't even know.
Print, like that kind of thing.
Yeah, it's very similar.
They don't sponsor the Celtics anymore. Did you see that?
No. Yeah. I mean, I definitely order some for you. We'll hook that up.
We'll talk. Yeah.
Yeah.
Whoever willfully, here's the statute. All right, no, I'll read to myself because I'm sorry. Go ahead, read your stuff. I'll read this.
Okay. Yeah, I mean, that's basically it. They wanted you to get the Young Jerk swag, it looks like. There's some other questions that came in. Someone wanted to know if they could find info on the Jen McCabe thing you were just talking about, where it's at.
During her cross-examination or direct examination, after obviously with Allie McCabe, the judge like let the door open wide improperly about the so-called witness harassment. At that point, Lally availed himself to just emptying the tank with Jennifer McCabe. And when she was on one of her absolute rants about the harassment, and I think she even named Turtle Boy, didn't she?
Yeah, she did.
During that rant and
Or the
rave, she was
blogger
saying,
or
the
something
kids
like
are coming to my kids' soccer games. They were doing this. And she said during that someone had sent either her or her kids, male human fluids, let's just say.
And you can, if you look on our live too on our YouTube, if you look on the live, I don't know what you call it, the feed, you scroll down, you can see all the court hearings. We broadcast most of them, so you could probably find it there if you look hard enough.
Yeah, this statute's garbage. I mean, you don't even have to read like all the sections. Whoever threatens, attempts, or causes physical, emotional, or economic injury or property damage, or conveys or does this or misleads, harasses someone who's a witness. I mean, if they're using the subsection about causing emotional injury, that's ridiculous. Now,
That's what they said, but the feelings get hurt, emotional injury.
That part of this statute is ridiculous. So that, I mean, I would add, a lot of times too, courts, if they don't want to strike the whole statute, they strike out
that part
and try to keep the rest of it. This one under subdivision B, little I, that says it threatens, attempts, or causes emotional injury. What does that even mean?
You hurt their feelings.
That's embarrassing.
Yeah.
Which is kind of funny too, because New England the whole area has that. The rest of the country thinks this is a place where you can speak your mind.
Yeah, F you.
You basically, you talk with your middle fingers, and you're just massholes, right?
Yeah, massholes.
And this statute is really weak.
Yeah, I mean, I think we're pretty much done today. I think we got most of the questions out of there.
They want you to do the Jen McCabe accent.
They want me to do it?
I think so, yeah.
What am I supposed to say?
I think it's a shock and horror.
Oh, shock and horror. I can't do it like her though. I'm North Shore. She's South Shore. It's a little.
It is different. It is a little different. It's a little more shrill down there.
And especially her, the way she talks, I can't do it. It's just, she's got a very distinctive. If I listened to it for a little while, I could imitate it, but I just can't do it from memory.
Are these people really going to testify at Turtle Boy's trial with all this going on?
I don't know. I know. The horror. Let me clear my throat first. I got my big gulp tonight.
The horror. It's not going to be as good as Marlon Brando in Apocalypse.
The horror. The horror of Aiden, that blogger.
It's, yeah. That's some nasally tone with those words was a perfect storm of oi.
It's too much.
It was a little over the top.
A little bit. She got a little animated.
Well, it's very contrived. It was.
You could see what actually. It's funny too. Like, if you really look at all of them, you could see what matters to them.
It's interesting that Brian Albert stayed under control. He did.
Yeah.
Colin Albert stayed under control. Brian Higgins was kind of an easier guy to mess around with, and he got a little more, you could see his wear it like, oh God, I just said something stupid, but he was under control. All of these people were under control except for her. Right? Isn't she the only one who just absolutely?
Yeah, they said that she was always ice, like she was, but you were right. Like, and what did she get mad about? What did she get mad about? It wasn't really about John O'Keefe, was it?
Well, she'll say that was my friend, and
that's not where her anger lies. Chris and her they're real angry is about what? That people make fun of them now.
I don't know.
That's really what it is. Like
I got to tell you, during the first trial, I know there was that evidence they had of when Karen Reed ran outside and just, fate works in mysterious ways, left her phone in the car as it was still leaving the voicemail. So John O'Keefe's phone is recording.
Yeah.
And I know that there was evidence in the first trial when she kind of whispered to Nicole about, they're sending someone or whatever it was. And none of us really gave that as much attention as we probably should have. And then you saw that video, the microdots video.
Microdots. Yeah.
By the way, those videos are like
very good,
spectacular. No, they are really effective and influential. But that one in particular, with the timeline of, all these calls and butt dials and whatever, but it's like the light went on in my head. That statement to Nicole Albert about, whispering quietly, they're sending someone without any other information, which again requires that you meet. So she must know something happened. That's on the level of the Google search. Now, it's not as shocking about the actual words, like how long to die in the cold. That just sounds like, oh my God, but it's the same principle. If Jennifer McCabe and Nicole Albert are talking about something without a prior description of what they're talking about, and she's calling Nicole at that very moment to say they're sending someone, like it's happening, it like launched the plan or whatever. How do they explain that? Why would you call Nicole and whisper and say that unless Nicole knew something was already going on, which she shouldn't, as McCabe shouldn't either.
It's like a smoking gun right there.
That's going to get, I bet you, much more play the second time around. I think everyone just kind of let that go, or just didn't hyper focus on that. And I would even argue that, compare it to the Google search and say they need to go 2 for 2. Don't let them off the hook with Jessica Hyde and Ian Whiffen on the Google search. Then whatever you think about that, they need to clear that call too from McCabe to Nicole, which they can't, because here it is. It's recorded on John O'Keefe's voicemail with a timestamp.
Now, they're making a comment about Turtle Boy because he's going to court tomorrow. And the special prosecutor, Mello, has missed every single deadline on discovery. He's like 4 weeks behind. It's the second or third judge.
I mean, there comes a point where, who's the judge? Don't tell me it's not her, is it?
No, it's like rotating. They never have the same judge, which is interesting.
Okay, that's fine. Well, then he ought to be sanctioned, and there ought to be severe sanctions. They should preclude evidence, and if it kills the case, it kills the case. But I mean, at what point is he not entitled to a fair and speedy trial like anyone else? Just because they don't like him in Canton because he's humiliating them all, that's good journalism. You may not like his methods, but he's done a lot of good work on the case, and you're arresting him. You're charging him with these stuff that really sounds ridiculous. He's entitled to his speedy trial. Let him have it. I'm sure he wants it. And if this guy is not equipped to satisfy his, prosecutorial duty, then there ought to be penalties and there ought to be sanctions. Evidence ought to be precluded. And I don't know why it doesn't happen. I don't know why. I mean, the stuff that was going on in this trial, Karen Reed's trial, with the late disclosure and the statements, and they don't get punished for it, was stunning to me. These guys would get killed in New York City if they tried pulling this crap, like in the middle of trial. The judge would have cleared the courtroom of the jury and said, are we doing a mistrial and without a retrial? Or what are we doing here? What are you seeking sanctions? And if so, what? I mean, the stuff that this DA gets away with because they're in their little home court it's another reason to potentially seek a change of venue. Just try to change the culture as much as you can, even if it is the same judge. Get them all out of their comfort zone and just hopefully that won't happen to him tomorrow. I mean, they can't make him start a trial if they haven't disclosed anything, but the answer just can't be, well, we'll adjourn it a month.
That's what they keep doing.
Well,
It's
but that
crazy.
then his lawyer has to step up and say
Yeah.
this is disgraceful.
Yeah, he's getting
He wants a
pretty.
speedy
Yeah,
trial, and there ought to be accountability. And the reality is this: I'm not saying that Aiden should be, the sacrificial lamb, because he shouldn't. He has to defend himself no matter what. But it's clearly in Karen Reed's best interest for the Turtle Boy trial to happen first. And one wonders if some of this discovery nonsense is trying to kick the can down the road and not allow that.
that's
Because
interesting.
if all these witnesses have to come in and testify against him, they could get damaged. And it's not even just, the Alberts and the McCabe's. Buchanan. I mean, is he going to come in and say that I was illegally wiretapped because he left a recorder on a urinal in the bathroom? I mean, really? A state police officer? But he could get cross-examined very heavily about a lot of things, about his, why do you have, you could attack him for his credibility, saying you have a vendetta against him.
He does.
And one of the
There's
reasons,
no question in my mind about it.
one of the reasons and then you go
Bukkake. He called him Bukkake.
Right, but more than that, one of the,
that's an easy
you got to go
one.
back. It is, but you got to go back even farther. The origin of the vendetta is he humiliated you and your partner in a case that you thought was this big case, and now you're getting attacked, and it's all Aiden's fault, right? It's all he outed you
killing me.
and did this, and then you can say, you hate him because he posted these videos. Is he the one who posted the video of this clown without his shirt, like hooting and hollering? That's probably him, right? And lead up into that. And, they may even try to get down to the text messages about, did you get text messages from Michael Proctor? And Michael Proctor's your friend, but you were his supervisor. And, as a supervisor, you're responsible for his behavior, right? Right. There are times where a supervisor is supposed to discipline a subordinate if they step out of line, right? Right. I'll give you an example. One of those things would be calling someone you arrest, see you next Tuesday, right? Did you supervise him? Or doing this? No, you liked it. And you're pissed at him because he exposed all this. And, this could all, and then you say, if he has a motive to get angry at all these people, I would even try to get into the video. Now, that may be a bridge too far in his trial, but, did he try to fix evidence against Karen Reed because he thought it would make him, if she's convicted, it helps him in the case against Turtle Boy? That may be inadmissible, but I'm making that argument. I'm trying. So you can see why, the Norfolk DA doesn't want this crap coming out before they retry Karen, if they really do that, which I still think they won't, but
we'll see.
We shall see.
I think they're zombie enough to try it. It's like Chris Albert. Like if he had been smart, he just would have resigned as a select board. Like I just go into those meetings. I don't know what he's trying to do.
How the hell did he get elected? I mean,
well, he didn't tell them that he didn't pay his taxes. He didn't tell everyone that he killed the man.
But the irony is, he's a witness in a case where a woman is accused of running over someone at 24 miles an hour and leaving the scene of an accident. Oh my God. Well, my guy, you went to jail for that. Right?
He should have resigned. As soon as it came out that he killed the man and he didn't tell the voters, that would have been an easy way just to say, you know what, buddy, I'm going to resign because people are upset with me. I agree. I should have probably told people that. So I'm going to resign for my family. That's what a real man would have done, in my opinion. But instead, he wants to pretend he's a tough guy, go to every meeting. And this is what he's doing to his own town just so he could prove a point. Like, it's just so, I don't get it.
Well, I don't know. But also, look, if you buy into the theory that they did something wrong as it relates to what happened, on the lawn of Brian Albert, it's not hard to understand why they wouldn't want someone in a position of power in the town.
There you go.
Now, I mean, again,
that's another reason why he should resign.
Right. But potentially from his perspective,
why? For self. I mean, that's where it goes back to. I talked about Jennifer and Chris. You could tell what they really care about. They care about themselves. They don't care about anybody else but themselves.
Well,
That's
you
what
know
all
that.
I see when I think of Chris Albert and Jennifer McCabe. I think of selfish people. That's what I always think of.
Well, you can tell in the way that they talked about John O'Keefe when they didn't think anyone else was listening.
Bingo.
Right? He's that guy. I mean, she's telling you in trial that I'm just destroyed by this. And, friends of John O'Keefe's would be destroyed by this, obviously. And she may have been friends with him. I'm not challenging that. But privately, these people were talking about, the guy. They were thinking about number one. They weren't worried about anything other than making sure that guy was never in our house. That doesn't sound like a very close relationship.
No, not at all. Someone's all right. I appreciate all the comments today. I'm trying to read the comments, but by the time I try to bring one up, they move by. Sometimes they're so quick. It's hard to keep up with the comments. I want to thank everyone who's been posting their questions and comments tonight. Mark, do you have any final thoughts tonight before we end this?
No, other than I think you're going to be getting more affidavits or affirmations from lawyers in the short term, and potentially the pressure is going to be so immense, and it's going to be really interesting to see how the DA and the court respond to this juror issue. You can't just sweep it aside and say you blew your chance. Okay. Lawyers on YouTube can say very easily that, oh, well, they didn't object at the time, so they waived it. Who cares? That's law school analysis. Okay. In the real world, when the cameras are rolling on a high profile case and a DA's office is under pressure, and there appears to be substantial and credible evidence that a woman may very well have been acquitted, and you want to retry her for murder, it's much harder to take that position in real life than it is, behind a keyboard. And it's going to be really interesting to see whether they continue to be zombies or at least recognize some degree of concern that a possibly acquitted defendant may get retried for crimes for which he was acquitted. And how are they going to sell that publicly? I mean, politically, if you're Morrissey. So this, a couple of weeks ago, we kind of laughed and said that the DA would have been better off with an acquittal rather than a hung jury. And it's been confirmed in a week, because they're in like major scandal mode right now. What do we do with this? And if they do the wrong thing here publicly, they're going to get killed even worse than they've already been getting killed. So that's my thought, is that you're going to get more of these affirmations, I believe, and you should really be watching how the DA responds, because I think it'll tell you a lot about whether they really have any soul as a prosecutor, or are they just truly soulless zombies.
I think they're going to be soulless. I think that's what's going to show.
I do too. I do too. But this one will be interesting. We'll see, because any normal prosecutor would tell you, my God, if 12 jurors come in a couple of days and say, I swear to God, we acquitted her, we didn't know, oh my God, it doesn't mean you have to agree with them. But you know what you're going to do? You ought to listen and be like, let's flesh this out. There's no harm as a minister of justice in making sure we did it right. And if their attitude is like, no, the jury's gone, no backsies, who cares? Well, then you should be concerned. Then they're soulless zombies.
We got one more question for you. They want to know what your favorite Framingham pizza spot is.
Well, first of all, we're talking like, years and years ago. But I remember a place, I think it was the only place that even delivered back then. It was called Tano's Pizza, I think. I think it was like Tano, Tano's Pizza. I mean, the Framingham Baking Company is pretty famous, but when I was much younger, and this is a long time, I haven't lived there in a long time.
Sounds like it would be good, actually. Tano.
It was very good. And, back then there was nobody really delivered. But yeah, Tano's was very good, but that was good. And my favorite place, bar none, was Lotus Flower Chinese food. When you could
now you're talking.
Kowloon's a little schlep, as you know,
I mean,
But,
Kowloon's like, yeah, I mean, it's okay. I mean, I like Kowloon, but there are other better places too.
I like the whole culture of it.
I
you know?
do too. I mean, I just like
I,
the old school Chinese. I do.
I like the whole culture, the whole kind of
I do.
driving on Route 1 and saying hello to the dinosaur that I
Yeah.
get to drive by. And
Oh, you know, my buddy made that dinosaur famous, Robbie Road Steamer. You know about that?
Really?
He got the tattoo on his arm. He's been on Fox 25 about that.
Really?
He's a musician. He's been done a bunch of TV and all kinds of stuff, but he's like, everyone knows him for the Route 1 dinosaur. It's so funny.
It's funny. It's just like there on a parking lot. I don't know why it's there, but there's
He
just
wrote songs about it. He
It's
just
just like
he
a
loves it.
pinkish
Like
orange-
I think that's the reason it's still there, because of him. Like I think they knew people would freak out because he's really focused on that Route 1 dinosaur.
I like seeing the old hilltop sign. That brings back crazy. I remember going there. Then I remember
love the
going to
Hilltop. That was so great back in the day.
we used to go to the one in Braintree. I know they had the other one. That's not there anymore either. You know,
Yeah,
the whole
they're all
thing-
gone.
Yeah, so
It's all gone.
Tano's Pizza though.
I love it. I'm gonna throw out West Dewberry Pizza if anyone knows that place. That
Which one?
place, West Dewberry Pizza. Oh my god, that was great. Greek pizza. It was Greek style. I mean,
Yeah.
I like the Italian style too. Believe me, I like it all. All right,
You know-
thank you. Well, go
Yeah,
ahead.
no, I
You
can
have another place you want to throw out?
No, it doesn't. It's just I'm just rambling about pizza. It
Pizza
doesn't-
places, Chinese food. Hey,
Hey, it's good stuff.
it is. All right, well, we'll see you. I'm sure
Yeah.
we'll see you again soon.
Yeah.
Thank you so much, Attorney Bederow.
All right, have a good one.
You too. Have a great night.
Bye.
Bye now. And my name is Mike Crawford. These Young Jerks. I'm trying to get to all the super chats. Too many coming in. It's such a tough problem to have, right? We had 93 again tonight. It's unbelievable. I don't get them all up and people get mad at me. I'm sorry. I try. Yeah, Jennifer McCabe did make a phone call. She did. She definitely did. I just want to make a couple comments too. Like, I know there's a lot of new people following us and just learning about the Young Jerks and checking us out. A lot of you are what do you call yourselves? True crimers. I am not. I don't consider the Young Jerks to be true crime, but I think you should follow us. I have exposed a lot of corruption over the years. And this week, there was a major thing that happened in the cannabis industry with the OIG of basically the main investigator at the State House, for the State House, independent investigator. He goes in there and he basically says all the shit that I reported on for like the last 5 years. So that's the show. That's who we are. Like, I expose shit. It's not always true crime. Usually it's more like political corruption or a state agency not doing a job or a company like Trulieve who killed their 27-year-old worker. And I drove him out of the state from here. Sitting here, I drove that friggin' multi-billion-dollar company out of my state. Like, I know a lot of you guys are here to be entertained and you nitpick and you criticize. I don't give a shit about it. All I care about is that you're here watching, and I appreciate that. But I'm not true crime. I'm true get shit done. That's what my show is about. It's a little different than some of those other shows. You may be like want to be entertained. You may like things like more NPR-ish, like really polished. That's not this place. Our place here on my show is like to push things forward, to allow communities we've been on the Karen Reed thing for so long now, for like the last year. But I just want to let you know, stick with us, because I'm gonna do some other shows that isn't Karen Reed. And I think you guys, if you like what we're doing with Karen Reed, you're gonna like what I'm doing with cannabis. You're gonna like what I'm doing with maybe the governor's council races. We're gonna have some candidates on. We are different. We're not maybe what you expect. And it's a good thing. And there's a track record here. I've been doing this shit for a long, long time. My first show was like 15 years ago with an attorney. Someone I was working with to get shit done. We changed 3 laws in Massachusetts. Like there aren't other, what do you call them? Lawfare shows. They haven't changed laws. I was a big part of the decrim campaign in Massachusetts. I got arrested for cannabis, and then I was on TV talking about it. That's who I am. And I was I looked so good on TV with my little dog telling my story, how they ruined my life over one joint, a medical joint, that like I was almost like the, I don't know, spokesperson in a way. So that's me. Like I expose things and I change things. That's what is different about our show than I think some of the other shows out there. So I want to let you know, because people are saying you should cover this case next, or this case, or this case. And it's like, I don't know. I more want to help people. That's what the show really has been about. We're trying to help Karen Reed right now. Someone said, will you have the Canton 9 on? We've already had them on. See, that's what my show is. It's helping people like the Canton 9. It's helping the women of Canton, even with the Karen Reed case. It's all, we've been trying to help people. And that's why I hope you stick with the show, even if we're not doing Karen Reed stuff, please. Because there's going to be a lot of other things that we're going to be covering. There's a lot of injustice out there. So when if you're new to this, I am not true crime. I know a lot of people want to call me true crime now. We're not true crime. We're not law tube. I'm not trying to be. We're more like get shit done tube. That's really what my show has been. And one of the things I was advocating for so strongly was workers, people who are getting screwed as workers in this country. And we're going to do a lot more of that. And I hope you support it. I hope you follow it. I hope you check it out. And if you have stories that you want covered, let me know. Someone said, oh, I have a cannabis question. Can we talk? Yeah, you can ask me. Definitely. Hit me up. You can hit me up on Twitter, at the Young Jerks. You can also hit us up on Facebook at the Young Jerks. I'm on Facebook too, so you can find me a couple different ways. And that's one of the reasons I focus so heavily on Canton in terms of the select board too. I saw what was going on. I've been to, probably 50 different town meetings. I mean, the thing about me that's different than maybe some of the law tubers or the true crime shows, I've had over 100 politicians on this show. I've interviewed 4 U.S. Congress reps and a U.S. senator. I've interviewed probably a dozen U.S. State senators on this show. I've interviewed probably a dozen mayors at this point, and probably about 50 different city councilors. So that's the type of show that we were kind of before this Karen Reed. And I think we're going to be a hybrid. I think we're going to go back to some of that stuff. And I just hope you stick with it. And if you have an issue in your town, call me, hit me up, let me know. I'm going to read a couple of Venmos, I think. Let's see. Dawn sent $9. Thank you so much, Dawn, on Venmo. Deborah sent 15. She says, do you think more jurors will start coming out? Yes. Attorney Bederow thinks so, and I think so too. Deborah's, yes. Christina sent me a message and she told me to check my Twitter and then show Mark. That's like too many steps at this point. I gotta say, guys, if you want something read right away, it's not gonna happen. Here's one that I should ask. Can we discuss the new attorney they just hired? That came from Deborah a couple nights ago. There was some comments here earlier. I should have actually asked that. I don't know if Mark knows them, but I should have asked that question. I gotta give myself a break on this stuff though sometimes, and I hope you do too, because I get so many requests to ask questions of Mark and other guests. I can't keep up with them all. It's impossible. Even on the super chats, even when you guys are giving me money, I can't keep up. 95 of them tonight. If you haven't, please subscribe. About half of you watching have not subscribed. Please subscribe tonight if you haven't done so yet. Ashley Gray, she sent $20 on the Cash App. And she wanted to know what water Bederow was drinking. Oh my God, that's so funny. I don't know. We missed that one. I'm sorry. We'll ask him next time. She wants to know what water he is drinking. All right, everyone. I want to thank you so much for watching, subscribing, commenting, all the super chats tonight. Thank you so much. That's a good question. Someone said, I don't know how they expect you to answer all these questions. It's true. Becomes too many sometimes. Someone said it was the Wegmans water is what Mark was drinking. He definitely drinking water. I don't know which one. Yeah, 95 super chats. And I didn't read them all. It's almost impossible. And a lot of times too, even on the super chats, they're repeat questions. If we've asked the question 10 times already, I'm not going to ask it again when you super chat me. And I think people don't realize that. They get very upset. And I am very thankful for all the support you guys give us. But I just want to let you know, I'm probably not going to be doing a lot of crime, like true crime stuff going forward. Just like I would not call Turtle Boy true crime either. Even though he's done some true crime, I wouldn't call his show true crime. I would say he's more about exposing corruption more than anything else. And I think that's what I do too. And helping people that are voiceless. That's what, if you look at what just happened at the State House this week with the cannabis issue, where they're talking about putting the Mass Cannabis Control Commission in receivership, I was talking about that for 7 years. And the reason why I was talking about that is because the workers came to me and said, this is what's going on. And no one would listen to them. And no one would listen to me when I went off and on it for like 3 or 4 years. And then a 27-year-old woman died. And those workers had predicted someone was going to die at work. And when she died, I started just putting it in everyone's face. All those people who did nothing in the media, as well as the commissioners, they actually covered it up. They didn't let anyone know that someone died and how she died at 27 years old, which was predicted by the workers. Guess what? Her mom started calling in. Her stepdad, her cousins, her aunt, her whole family started calling into my show. And you know what? The media freaked the F out. The media started reporting on it. They started quoting me. The Boston Globe, who was ignoring me, put an editorial and said, yeah, the young jerks are right. They reported it first. We got to fix this. That's what my show is about. And we still haven't finished that story. Like I got so frustrated. I had to kind of step back. And then Karen Reed came along. Karen Reed has almost been a vacation for me for that, because I was so caught up in that story. And it started really messing me up that we weren't getting enough progress soon enough. But to see something like that happen this week, It did. It made me feel good. And I know that Lorna's family is going to get justice. She's got a great lawyer. Her mom's suing them. We got True Leaf to leave the state of Massachusetts. They are the shadiest cannabis corporation in America. And her name was Lorna McMurray. She was 27 years old. She didn't need to die at work. She collapsed in December, right before Christmas. Had a major incident, taken out of work in an ambulance, having breathing issues. In January, she collapsed again at work and she died. She never got home. And the company never protected her. The company never alerted her to the risks that we all know are there. And these big cannabis companies, when you have major grows indoor, if you don't have proper ventilation, a lot of particle count, a lot of this stuff gets dried in the air. People get sick. And especially if there's mold, powdery mildew, toxins, which almost always exist in this, and these big companies that don't do the right thing. And that's how you have a 27-year-old have a major heart attack and die for just working at their cannabis company. They think it's safe. And this is what started a change in Massachusetts. But this Cannabis Control Commission, they covered it up. They did nothing. They recently levied one of the biggest fines that they've ever levied against True Leaf, but it took them years to do that. And this week, the chairwoman of the Cannabis Control Commission, who did nothing for Lorna, who didn't champion Lorna, who didn't allow the workers to have a public hearing, she said, we shouldn't be under receivership because we just help Lorna, we just help workers. So it's still going on. So expect more on that. Have a great night, everyone. I'll see you soon.